Daily cause list, item number 1 for pronouncement of judgment.
So I'll read only the operative portion. In the light of the above, this court is of the considered opinion that no effective order can be passed in the instant matter in view of the stated position of law as is found in subsection 3 of section 28I of the Northeastern Areas Reorganization Act 1971 as amended by section 4 of the Northeastern Areas Reorganization and Other Related Laws Amendment Act 2012. This petition is accordingly dismissed. Before parting, it may be pointed out that in view of the aforementioned provision of law, it is open to the petitioner to approach the Common High Court without prejudice to his right in spite of the observations made herein above. So that much leeway is given to you in approaching Common High Court. It may come back here for all we know.
Yes, Your Lordship. Much obliged, Much obliged.
Please, Your Lordship. Your Lordship, filing this mention memo for moving of an unlisted matter, Your Lordship. It's of extreme urgency is there.
What?
The matter is about I'm functioning as a CM of Himalangaran right now. What happened is that some complaints were filed by some youth organization, which is a busybody, before the district council. And they've issued me show cause notice. I've replied. And I've made a specific prayer that I may be allowed to be heard in person. Now what has happened, Your Lordship, on Friday evening, they have suspended me without assigning any reasons. Your Lordship, I'm before Your Lordship because I have several other grounds whereby, Your Lordship, the main allegations in their complaint is with regard to a land compensation, which I have received. Against that, Your Lordship, there are few interested people who have filed a petition before this court, which is pending before this court. Now the executive committee further has frozen my account also, saying that I cannot spend money beyond 25,000, in which they have no power or no jurisdiction to. So there's several other grounds which all those issues are agitated before this honorable court and before the trial court. Now the executive committee, without any basis or without any substance, have suspended me. So I pray that the matter will come at the end of the boat.
But suspension is a process.
No, Lordship. Procedures shall be followed. There's a violation of the Act, Section 7 and Section 9. I'll place some similar orders which were passed in 2014, whereby this honorable court also has passed certain interim orders, Lordship. Obliged. At the end of the boat.
It can come up tomorrow, so.
It's urgency, Lordship, because now, without following the statutory provision, now they'll force me to hand over, Your Lordship. It's a similar case in 2014, identical case.
But whatever the case may be, Mr. Nombre, the other side has to be.
Yes, we'll serve them a copy. Obliged.
Have you filed the petition?
Yes,
May it please Your Lordship. Lordship, I beg to make a mention of item 8. Lordship, I'm praying if this matter may be listed after 2 weeks.
This matter, every time it comes up, every time, someone or the other would ask for time. What's the matter about? Who is the petitioner? You are the petitioner?
I'm the respondent, Lordship.
What's this matter about, Mr. Saad?
My lord, actually, CC Sama is handling the brief, man. So, they just informed me just now, man, because my senior is there.
Is it
2 weeks, Lordship.
2020 matter? How many respondents are here?
Just a private respondent, Lordship, just one.
On prayer made by the respondent, not objected to by the petitioner. Matter is adjourned. Please assume after
2 weeks, Lordship.
2 weeks.
2 weeks.
Highly obliged, Lordship.
But there's a joint request in item 9 and 10, my lord. This matter has just been placed before this honorable court, my lord. It was a disabled matter from the other court. A joint request if this matter can be taken up after 2 weeks.
Again, it's a 2020 matter.
Yes, my lord. This matter was previously heard by the other bench. It was sent for my lord, to Lok Adalat, and then after coming back from there, it has not been heard till now. So not, then it went to the other court, disabled. Now it's come before your lordship.
What is the matter about?
Lord, this is prolonged suspension, my lord. The issue is very short, but the matter is very lengthy. The facts are very lengthy. Issues, there's a prolonged suspension of over 10 years. Not 10 years, not 7 years. So that's the issue, my lord.
That should not be.
The issue is very small.
Whatever the case may be, see, the
That
process.
is their case, your lordship. Our case is, it is a case of voluntary abandonment of service. On their own, they have left the service.
No, but what is, you see, they may have left the service, but what about the process of a suspension?
Lordship, if they have left the service on their own, so there is no question of termination, because there is a dispute, your lordship, regarding two schools. One is a Roman Catholic LP school, and one set up by them. So they went to their own school, which they had set up, your lordship.
Whatever it may be, my lord, the last order suspension approved by the government, till date, my lord, no proceedings, no nothing, continuous, my lord, indefinite. 2 weeks, my lord.
2 weeks.
9 and 10, my lord.
Today is what date? Today is
You are for the petitioner?
I'm for the petitioner, my lord.
On prayer made by the petitioner?
Joint request, my lord.
On prayer made by the parties? List this matter up to 2 weeks.
Deep.
apply, your lordship.
Please, Your Lordship, I pray that I may be allowed to file one mention memo for tomorrow's date, Your Lordship. The urgency in the matter is we are planning to file an anticipatory bail, Your Lordship, and the accused person is apprehending arrest.
That is, you have filed your petition.
I will file in the court today, Your Lordship.
You can do it, you can file, and then it will be listed.
For tomorrow's
If you
date,
file
Your
it today,
Lordship.
then it will be listed tomorrow.
Usually it used to be listed in the other day, Your Lordship.
Okay. Yes, sir.
May I please, Your Lordship, I beg to mention item number 12, Lordship. I beg to mention item number 12 from the main list, Lordship. I pray for some more time, Lordship. Yeah.
What is this matter about?
It's a dismissal from service, Lordship,
See,
whereby the petitioner was approved in police.
that is why, you see, this court would request upon the parties, especially service matter, dismissal, suspension, they should be disposed or transferred, should be disposed of as early as possible. Otherwise, what happens is, as has been observed by this court or by the courts, matter is disposed after 10 years or 12 years or even 5 years.
The earlier
Then it
is
becomes-
heard, your lordship, is the better is for the petitioner. For the state, your lordship, he has been terminated from service. So
Yes, should be. In fact, the petitioner should be diligent. On premier petitioner, this is matter after 2 weeks.
apply,
Apply,
your
Lordship.
lordship.
Lordship, I beg to mention item number 11, Lordship. I'm paying for 2 weeks' time, Your Lordship.
Why?
Mr. Piti Sangma, he's not well, Your Lordship, today.
prayer has been made on behalf of the legal counsel for the petitioner, who is said to be indisposed on grounds of personal difficulty. Accordingly, as prayed for, matter is adjourned. Let's see after 2 weeks.
Obliged, Your Lordship.
It doesn't matter. He has asked for time. Otherwise, if you object, it will be noted.
Obliged, Your Lordship.
Daily cost list item number 2.
Lordship, we have taken steps on respondent to MPSC. The matter was, my lord, transferred by the coordinate bench.
My lord, this matter, if Lordship can come to the page, my lord, page 67, annexure 7 of the writ petition, my lord. Okay.
Page 67, my lord, annexure 7.
Yes.
Lordship, this is an order, my lord, in writ petition 466 of 2021. Matter is pending before this bench, my lord. It's listed at item 13 today. Here, my lord, there is a interim direction. If Lordship sees at the last paragraph, 3 lines from the bottom, my lord. If in the event, Lordship has it.
Yes.
If in the event the selection process continues to its culmination, the result of such selection process is not to be published, which is contingent to the disposal of this writ petition. Matter, my lord, is still pending. Here, my lord, if I may humbly submit, my lord, what has happened is there was an advertisement in 2017 floated by the MPSC. A list of posts were, my lord, advertised. Lordship will kindly have the advertisement, my lord, at page 43. Page 43, my lord, annexure 2,
yes,
is the advertisement issued by the MPSC on 26th April 2017, Lordship. Lordship may kindly have page 45. All the posts are, my lord, listed at serial 9, Lordship, the one at top, Enforcement Inspector under the Transport Department.
yes,
Number of posts, Lordship, is 4. So this is what we are concerned with, my lord, the petitioners herein. Lordship will kindly note that this is a advertisement for 4 posts of Enforcement Inspector to be recruited by way of direct recruitment. The qualifications are given, Lordship, at the column. My lord, pursuant to this advertisement, the selection process was held by the MPSC, and at page, my lord, 66, excuse me, page 66, my lord, annexure 6. This is, my lord, a notification where, my lord, the persons who had sat in the selection process, the written examination, have been listed, who all have qualified, Lordship. 20 numbers had qualified, and thereafter it was also, my lord, informed that the personal interview will be held on 16th and 17th of December 2021. These are for the 4 posts, my lord, pursuant to the advertisement. In the meanwhile, my lord, kindly have the next page, my lord, again at page 67. This is also an order of 17/12, my lord, which is the date on which the interview was supposed to be held. Lordship, there was a interim direction granted by this court to not publish the result of the selection process. But here, my lord, my only submission is that this selection process which has been stayed by this honorable court is in connection with the posts which are to be filled by promotion, not the posts which are to be filled by direct recruitment. Lordship will kindly have, my lord, the next page at page 68. This is the, my lord, order of the division bench, also concerning the same issue, my lord. At page 69, Lordship will have the date of the order, which is of 21st March 2022. Lordship will kindly see the first paragraph itself, my lord, judgment, at page 70. The propriety of a decision by the Transport Department of the state to create several posts in the rank of Assistant Enforcement Inspector by a notification of so and so falls for consideration. So this is, my lord, in connection with the post of Assistant Enforcement Inspector to be promoted to the post of Enforcement Inspector, which was, my lord, issued by notification of September 26th. Lordship will kindly have page 75, my lord. Page 75, para 16, Lordship, if I may read.
yes,
Accordingly, the impugn notification of so and so, insofar as it provides for discriminatory promotion from among the enforcement checkers based on educational qualifications, is set aside, and all action taken pursuant thereto are set at naught. So, my lord, division bench set aside the notification. What happened, my lord, was that in this notification of November 26th, our qualification was given of graduate for promotion of the checkers to the next post of assistant inspectors. That notification was challenged on the ground of the educational qualification being discriminatory, and it was eventually set aside, my lord. The same petitioner's lordship have filed the petition which is now pending before this bench, where the interim stay has been granted on the selection process. But in any case, my lord, my humble submission is that this entire proceedings which are before this court as well as taken up before the Supreme Court are in connection with the posts which are to be filled up by promotion from the people who are already in service in the transport department, who are supposed to be promoted. Whereas, my lord, here the petitioners are before your lordships in connection with a selection process which was to be filled up by direct recruitment, which had culminated till the stage of interview, but unfortunately the results were never declared. Representations were filed, lordship. Lordship will kindly have the representation at before that, my lord, kindly have page 77. Page 77, lordship, is an order of 12th of May. Lordship has it. Right? This is, my lord, if I'm in pursuant to the common judgment and order of the Honorable High Court of Meghalaya dated so and so in WPC so and so and WA number so and so, the following assistant enforcement inspectors are hereby reverted to the original post of enforcement checker, which they were holding wide order dated so and dated so and so. So, pursuant to the direction of the division bench, my lord, which set aside the notification and all actions taken pursuant thereto, these people who were promoted were reverted back. And lordship will see the first name, my lord, Shri Damien Rongrin. This is the same person who has filed the pending writ petition before this court. These, my lord, have nothing to do, in my humble submission, with what these petitioners here are concerned with. Lordship will have the representation at Annexure 10, page 78. My lord, representation was filed to the commissioner. Lordship may kindly have the overleaf at page 79, paragraph 6, my lord.
Yes.
Lordship, on 16 December 2021, during the interview process, the checkers / assistant enforcement inspectors under the transport department have filed a case in Honorable High Court Shillong, wherein the Honorable Judge of the High Court has given an order that the result of selection process is not to be published. This is the, my lord, order passed by your lordships. The post of checkers, assistant inspectors, enforcement inspector under transport department are recruited under district selection committee and not through MPSC. So, my lord, what they are trying to say is that they are completely two different processes. One is in connection with promotion to be conducted by the district selection committee that has been stayed. Here, my lord, the petitioners are concerned with the direct recruitment, and they have nothing to do with assistant inspector or checkers. They are directly to be appointed, my lord, at the post of enforcement inspector, which is the highest post in the department in this cadre, my lord. So my humble submission is, my lord, that the pendency of the other matter may not have a bearing in this matter, because this matter, my lord, pertains to the selection process.
Direct recruitment vis-a-vis the promotional
post, my lord.
You are the petitioner.
I am the petitioner in this matter, my lord. In the other matter which is pending, Mr. Philemon is there. That is at item 13.
What is your prayer here then?
My prayer is for declaration of the results, my lord. Because it appears that because of the stay and everything, the results for the direct recruitment also were never declared.
Okay. So this court is called upon to distinguish the orders passed by the court.
Essentially, yes, my lord. That is the exercise that we have to undertake. That whether those matters where the interim direction has been passed have a bearing on this particular process of the 4 posts to be filled up by direct recruitment.
So you are one of those candidates which falls within those 20.
Those 20, my lord. 3 petitioners are here. All 3 are part of that 20.
Have the respondents filed their affidavit?
No, my lord, it was only listed for motion today from the other court. It's still listed for motion, lordship.
Motion. So, Mr. Shula, you are appearing for?
May it please your lordship. Lordship, R1, your lordship. R1, your lordship.
What about MPSC?
We have taken steps. I don't think service is completed now. We have taken steps on 7th of August.
Okay. So, when you file your counter?
Lordship, let the maintainability of this writ petition be decided first, your lordship, because it is now it is the admitted fact, your lordship, that the petitioner herein they are aware of the proceeding in item number 12 and 13, your lordship. So what they should do, your lordship, because they want the declaration of the result. We can MPSC cannot declare the result, or the state government cannot give the appointment, your lordship, because there is an order. There is an order passed by this court. Halting the publication of the result, your lordship. So in that way, your lordship, the petitioner should do so, not directly by a writ petition, your lordship. I should not give any suggestion, your lordship.
Our submission is there are two different, my lord, processes altogether. There is no question of challenging that.
I'm not on that, your lordship. What will be the remedy for them, your lordship?
But they have filed a representation.
If the representation can be disposed of
for
disposing that representation, that is fine, your lordship.
Yes, Mr. Dev, come again. You
have for disposing the representation, your lordship.
You have referred to a representation filed to the Commissioner.
Yes, your lord. That is at page 78.
Lordship, kindly come to page 33 of the writ petition.
33 or 78?
No, 33, your lordship. I'm the relief claim in the writ petition. Their main, the petitioner main grievance is non-disposal of their representation dated 2/1/2023.
Where is it?
Of January 23, your lordship. Your lordship will find it at page 33.
Yes, Mr. Dev.
My lord, prayer E is also there, my lord, for declaration of the results.
Oh, but you see, firstly we have to take one thing at a time.
My lord, if I may humbly submit, my lord, since the representation is pending, admittedly, we are basically, my lord, still not in a clear picture whether these people have the same, are connected with the same recruitment. If they dispose of the representation, my lord, or file an affidavit for clarification.
What happened is, you see, if the representation is disposed of,
Lordship.
you will know where you stand.
Lordship, yes.
It could go either way.
Lordship, yes.
And on the basis of that, you may have cause of action.
Lordship.
To come before the court.
Lordship, that may be. Let them dispose it within a week or two, my lord.
Who's
since
to dispose
January.
it?
Lordship, the Public Service Commission. Because
Where
here is the challenge is to the...
Where is...
representation was filed to the state authority.
Yes.
At page 78.
Yes. It was filed to you, Mr.
State cannot, your lordship, because the advertisement is...
Whatever the case may be, a representation has been filed.
if
you feel
the
that
advertisement is conducted by the MPSC, your lordship.
Now the prayer made is for this representation to be disposed of.
Let them file.
If you feel that you cannot dispose this representation effectively, then you reply accordingly.
Okay. Then they can file an affidavit. The picture will be clear.
I think what we can direct is direct the representation to be disposed of in whatever way they choose to dispose it, and thereafter, as has been observed by this court, you may have a course of action to come before this court again.
Lordship, if I may pray, in that case, my lord, we'll file a representation today itself in fresh to both the state and the MPSC.
But this representation is already there.
Because if they simply reply, my lord, saying that we are not the concerned authority.
No, that is not how it's to be done.
No, that, my lord,
you have filed it. It is officially received with them.
Lordship, a speaking order should
whether
be...
they are the authority to dispose of the representation or not, that is up to them.
Lordship.
So they will reply to you.
Lordship.
Thereafter, you are free to file a fresh representation to the concerned authority, either PSC or otherwise.
Lordship.
So we'll do it that way.
Or they may file in addition to this also they may file a fresh representation.
That is what you see. He is at liberty to file a fresh representation. If you want to withdraw this at this stage,
Let them dispose it, my lord, because I'll not be able to bring any new facts. Whatever is, they can dispose it.
What I mean to submit is a representative should be to the appropriate
Yes, yes. So you
who will take a decision, Your Lordship.
exactly, Mr. Shulai. What you do is, on the basis of this representation, you reply to them and say that this is not maintainable as far as you are concerned, and they have to approach the concerned department or authority. Simple as that, and they will do it.
1 week, my lord, for them to reply. That shouldn't take more than 1 week.
Yeah, it should be.
Dispose it, Your Lordship. Then the representative may be disposed of.
Yes, and dispose it.
Let it be 2 weeks, Your Lordship, not 1 week.
Heard the established counsel for the petitioner. Also heard Mr. Shulai and AAG.
For the respondent number
For
1.
respondent number 1 and Mr. Vikriam for respondent number 2. Without going to the merits of this petition, suffice it to say that the petitioner inter alia has made a prayer for disposal of a representation dated 2/1/2023 filed before the Commissioner of Transport Department, Government of Meghalaya, by the petitioners herein for an alleged infringement of their right vis-a-vis the advertisement for the post of enforcement inspector, which was floated in the year 2000.
At point 1 it's there. 26th April 2017.
Which was floated on
26th April 2017, my lord.
26 April 2017. From the submission made by the parties herein, what could be understood is that once the representation aforementioned is disposed of, the parties would know the position of the case vis-a-vis their rights, or rather the infringement of their rights as regard the subject matter aforementioned, as regard the subject matter indicated above. It is also the prayer of the petitioner that if the concerned authority dispose of the petition, then the petitioner may be allowed to take fresh steps of fresh course of action based on the outcome thereof. Mr. Dealer AAG has also concurred with the submission made and has submitted that the representation will be accordingly disposed of as expeditiously as possible.
Lordship, may I make a submission, Your Lordship? If the representation is already filed, Your Lordship, because looking by the page 78, Your Lordship, there is no thing to show that the representation has been received by the office, Your Lordship. Lordship, kindly come to page 78, Your Lordship, annexure 10. And then Lordship, kindly come to page 71, Your Lordship. There is no 79, Your Lordship. There is nothing to show that that representation has been received by the department concerned.
What do you have filed, Mr. Dev?
Lordship, we have filed it. In that case, my lord, what I would submit again, my lord, that let this representation, we'll file a fresh representation along with the copy of this order. Let them dispose it, my lord. But otherwise, on instructions, it was given to them.
Withdraw this petition.
No, Lordship, to withdraw it again, we have to, my lord.
Fresh liberty will be given to you to file fresh one.
Yes.
No, my lord, what I would submit is that a simple direction will be passed, my lord, that we'll file a representation along with the copy of this honorable court's order. Let them dispose it within 2 weeks, my lord.
See, you have annexed a representation.
This was given to them,
Copy
my
of
lord.
that. Now, it has been countered that the same may not have been filed at all.
Lordship, yes.
Now, you have your receipt with you? We produce the receipt.
My lord, because I was under instruction that it was given on by hand by the, but of course the
How can you do that?
No, but it was given, my lord, because on instruction I'm saying I was, but that's why I'm suggesting, my lord, that I may be allowed to file a fresh representation. They can consider it and dispose it, my lord. That way, even we can file one to the MPSC as well, lord.
Then you withdraw the red petition. Then the red petition will withdraw, your lordship.
Okay, we'll just
Simply giving the red petitioner liberty to file fresh representation to the.
because that they will do. They will in any case, even if this court doesn't give them liberty, they are still within their rights to file a representation. Going to the last line. At this juncture, the learned counsel for petitioner has submitted that, irrespective of the said representation dated in January being filed before the concerned authority, the petitioners may be allowed to file a fresh representation before the appropriate authorities for redressal of their grievances. Learned AAG has no objection to this proposition. Accordingly, as observed above, without touching on the merits of this petition, the petition is hereby disposed of with liberty to the petitioners to take necessary steps in accordance with law.
Apply.
That's it.
Then in lordship, then item 13 and 14 will. Since there is an observation, your lordship, that await the outcome of the SLP filed by them, your lordship.
So that of course, but we are on a different subject altogether. Why are you?
Because my lord, in the causal list, in terms of the last order, it's
Your
listed
lordship,
along with,
listed along
with 466 of 2021.
Oh, what is this 466?
lordship, that is
where the
That is my petition, my lord, where I say
red
that the
petition
rules
filed by
provide,
the.
where the rules provide 33% is by promotion and 66 by direct recruitment. 15 posts are already filled by direct recruitment, my lord. 6 posts have to be reserved for promotion, my lord. That is why, my lord, your lordship had issued the interim order, my lord.
Of 466 at serial number 14.
Yes, we have 14 and 465 at serial number 13.
Let the matter be called up and I'll pass this order.
Lordship.
It will be confusing, jumping from one to the other.
Apply, your lordship.
Obliged, lordship.
Item number 4.
Lordship, I pray that the matter will be taken up at the bottom of the list, Lordship, because the arguing counsel is in DP, Lordship. Mr. Ashish. Do oblige, Lordship.
Item number 6.
My Lord, this is the same matter which Mr. Philemon Longri has made a submission.
Where's he? He was here just now.
And number 13, my Lord, if I may submit, this matter is pending before the Apex Court and we are still waiting for the outcome in 465/2021. And in item number 14, my Lord, the same petitioners has also filed here, my Lord. Most recently, Lordship has also stayed the entire operation. So, my Lord, that was what we were submitting, my senior colleague was submitting.
No, so 13 and 14 are different?
Yeah, they are both, my Lord, connected matter, my Lord, but recruitment of different year, my Lord.
But item 13 is of advertisement of 2020 and item 14 is of 2017.
Same petitioner?
Same petitioners, but two different advertisements, so we had to challenge it separately.
Okay. So as far as item 13 is concerned, you say it's sub judice before the Apex Court?
Yes, my Lord, both the matters.
Both the matters.
Oh, both.
However,
the issues are very interconnected, my Lord. There is previous litigation relating to assistant inspector
and the qualification and all those.
Qualification, my Lord. So now in these two particular petitioners, irrespective of the outcome in those challenge, my Lord, which your lordships had decided sitting in division bench, they are qualified both by seniority also and by being by virtue of being graduates also. So their stand is, irrespective of the outcome of those petitions, we will still hold the post of assistant and we will be entitled to be considered for promotion to inspector. So that is why we, before your lordship, that if they exhaust the post by direct recruitment, my Lord, then it violates the rules and we will be at the loss, my Lord. So that's why.
So what is the post you are holding right now?
My lord, previously for 8 years we were holding assistant inspector, enforcement inspector. After your lordship's judgment, my lord, we were
Oh, you
demoted.
reverted back.
Reverted back. But if the government were to act on the judgment, my lord, I will still be promoted because in seniority also I am number 2. And the other person seniority number 4, my lord. So irrespective of the outcome, in any case, we have to be promoted. So that is the issue, my lord.
Any news on the proceedings before this?
Proceedings, my lord, there we have, it's at the stage of service because we are unable to serve the other side. They are not accepting
You are the
notice.
petitioner there?
No, not me. The petitioners who have filed, the other persons similarly situated, they are taking steps, my lord, which is not being delivered till date.
And have you been arraigned as a party respondent?
Pro forma, my lord.
Before.
4 weeks, my lord.
The counsel for the parties have submitted that the subject matter of this petition is also connected to a similar issue, which issue is now being looked into by the Apex Court in related proceedings. As submitted earlier, the outcome of the proceedings before the Apex Court in one way or the other would have an impact or bearing on the proceedings herein. It is therefore prayed that this matter will be kept in abeyance for the time being. As prayed for, place this matter after 4 weeks. So that's for 13 and 14. Same order. Huh?
Item number 15.
Your Lordship, I pray for an adjournment for this matter as his senior learned counsel is unwell.
You are for?
Cantonment, Your Lordship. Respondent number 4.
Cantonment, but
Respondent
respondent?
number 4. 1 and 2.
1 and 2.
I'm for respondent number 327.
1 and 2, Your Lordship.
Who's for the petitioner?
Petitioner Mr. Sen. Subhashis.
He's not here. Or is he on legs before some other courts?
Yes, morning time I have seen him. Anyhow, we are praying for adjournment only.
No, but he has to. If if the petitioner is here, he may press for it, or he may be he may wanted to be heard, or all those things. Okay, we'll take it up at the end of the board then.
Yes.
In the meantime, just try to find out if he is around. If not, pass his orders.
Item number 16.
My lord, this relates to the service matter. My lord, we are challenging the accreditation list as well as the promotion of my junior, my lord, to the post of the LDA, my lord, and the petitioner will be retiring very soon. So may I proceed?
May please your lordship to conduct counsel Mr. K. Khan on next before courtroom number 1.
He can come and join in the meantime. My friends are here.
So I'm not aware of this.
Leonard EHC can come and join.
My lord, it can be taken at the end of the board.
Every matter is taken at the end of the board. I know. He's just going through a cycle. Of course, if he's on legs in the other courts,
right?
Respect us, we can do that.
After some time.
Okay, we'll take it up.
Right.
Item number 17.
Your Lordship, I pray for an adjournment since the senior counsel is unwell. Your Lordship, I pray to grant us 3 weeks' time.
What is this matter about?
CMG University matter.
Saliba.
What a degree?
Yes, no degree. I'm appearing for the education department. Mr. Datta was appearing for CMG University.
He's not here. Who's respondent? Who's respondent number 1?
One is also state work presented by.
Oh. Last time around you were not here. Accommodation has been sought for on behalf of the petitioner on the ground of the fact that the learned senior conducting counsel is indisposed and could not appear for the court today. It is also noticed that apart from the respondents 1 and 2 respectively, respondents number 3 and 4 are not represented. This being the case, the prayer made is allowed. As prayed for, this is matter to 3 weeks.
Item number 18.
Chair, I appear for the respondent on behalf of senior counsel, especially engaged in this matter.
So,
for the first time.
The wanted time, I think his senior has informed me.
Preparations.
That he wanted sometime some instruction or something.
how many respondents are here?
One sole respondent.
Only one. Mr. M.L. Nopio, learned counsel for the respondent, has submitted that has made a prayer for adjournment in this matter on the ground that the learned senior counsel who is conducting the matter could not be present today. The prayer not being objected to by the petitioner, the same is allowed. How long?
After 2 weeks.
This matter to 2 weeks.
Much obliged.
Second call, item number 5.
Yes.
May
Please
Lordship. Lordship, here that I have filed my written submission, Lordship, and matter was orally heard long time back, Lordship. So I just want to refresh again, Lordship.
That is the problem.
Yes, Lordship. Here, Lordship.
Yes, sir. Drink dusting. Please start.
Yes, Lordship. The petitioner school, the LP school, Lordship, was established in the year 2000, Lordship. The opening permission of the school, Lordship, is at page 17 of my read petition, Lordship.
Page
17. 17, Lordship. That is the type copy. 16 is the original copy and 17 is the type copy, Lordship. So, may I read, Lordship? Please. Under the authority convened by the Director of Elementary and Mass Education, Meghalaya, Shillong, number so-and-so, the Tilapara Girls Primary School is hereby granted opening permission with effect from the date of issue of this order under the following terms and conditions. That granting of opening permission does not entail any financial commitment on the part of the government. The sponsoring body of the school should not be the managing committee or any individual. All schools are to ensure that the sponsoring body, which may be local darbar or strong local volunteer organization, is financially sound so that the school is able to survive without government assistance. The school was established prior to the getting of that opening permission. Subsequently, November 20 to the 2000, Lordship, 2000 got the permission with the condition that it is up to the management. Government is not responsible for granting any aid to the school. So at the time of establishment, Lordship, then 3 teachers were appointed, Lordship, 1 head and 2 assistant teachers. Since, Lordship, it is a private school, Lordship, government is not giving any aid.
So it's not even a government aided school?
No, Lordship, that time, no. Then headmasters resigned. He got better avenues and he left. And one of the assistants also, he left. Then in place of the headmasters, the petitioner was appointed in the year 2001, Lordship. The appointment order, Lordship.
So that is appointment would be by the management.
By the management committee, because it is entirely running at the cost of the management, Lordship.
Okay.
Then she was appointed in.
Who is for the managing committee?
Managing committee at present there is no managing committee, Lordship.
Oh, then.
There is no managing committee.
You have not read them as a respondent?
No, Lordship, because since there is no managing committee, because that is why the problem started, Lordship.
And who appointed you and who you have come here against
against the order made by the state, Lordship. That is my case.
State?
Yes. There was no managing committee 14 till date. Then I may be allowed to. I'll come later, Lordship. Yes,
please.
Then, Lordship, totally running at the mercy of the management, Lordship. That appointment is very clear. Appointment of the respondent as well as my appointment also, that as per the fixation made by the management committee. Then in due course of time, Lordship, that government has given aid. School was brought under SSA sometime in the year 2002 or 2003, Lordship. Then, Lordship, it was running under the management. Government is giving aid through the, and teachers are being paid through the management of the school. Now, Lordship, after August 14, 2014, there was no managing committee, Lordship. Then, same year, Lordship, the private respondent, he filed a representation claiming for post of headmaster on the basis of seniority. Her contention is that since she joined at the time when the school was established, and I joined 2001 after the headmaster of the school left the school. So her contention is that she is senior, I am junior. That is why she laid the claim of the headmaster based on the seniority, based on the joining reports. Then, Lordship, my Lord, the representation, my Lord, will find in the government affidavit, Lordship, that is at page.
Who filed the representation?
Government, that is respondent number 1 to 6, Lordship.
No. Who has filed the representation?
Respondent number 5, Lordship, on behalf of the others. That is at page 32, Lordship, in government affidavit.
Just a moment. Government, government is respondent.
1 to 6, but respondent number 5 has filed the counter, Lordship. That is, I have, Lordship, I have mentioned in my written submission.
35 to So you are referring to the affidavit in opposition filed by the respondent 5.
5, page 32, Lordship.
Dated? When was the affidavit filed?
It was filed on 5/7/2016.
Okay. Here it's 4/7.
17. What is here? 17. Page 32 of the represent.
Just one. 2017. And page 32 is the
representation
to the DMC.
Yes, this is the respondent number 4, Lordship.
Just read out.
This is the respondent number 4, Lordship. Petition for promotion to the post of head teacher on seniority basis, Lordship. The representation was filed on 29 November 2014.
Yes.
Sir, I have the honor to draw your kind attention to the subject mentioned above and state that I am a founder teacher of Tilapara Girls SSLP School.
Yes.
Under District Mission Coordinator and Sub-Divisional School Education Officer, Tadingiri, West Garo Hills. That sir, the school was established in the year 2000, Lordship, and at that time 3 teachers, including myself, Dilwar Hossain, head teacher, and 1 Oleda Sheikh, a first assistant, and Sri Deepak Shah, second assistant, were appointed by the managing committee of the school. Lordship. That I was appointed as first assistant in the year by appointment order dated 29/1/2000, and I have joined my post on 30/1/2000. They have enclosed the copy of the appointment of the private respondent in the same counter, Lordship. That's all. In the meantime, that's what I have stated, Lordship, that in the meantime that headmaster resigned, then I was appointed in his place. Then he claimed that she joined in the year 2000 and I joined in the year 2001. So based on the seniority that I should be appointed, I should be promoted to the post of headmaster. Now, my lord, then acting on the complaint, acting on the representation, Lordship, the respondent number 4, to whom the representation was addressed, forwarded the
Yes, Oleda Sheikh is the respondent number 7.
7.
Okay.
She has filed the representation for promotion.
Okay.
For promotion. Now, that representation was forwarded by the respondent number 4 to the respondent number 5 to conduct an inquiry with regard to the issue of seniority. Then, Lordship, then the respondent number 5, that is the sub-divisional officer, he directed the respondent block level officer, that is the respondent number 6, to conduct an inquiry. An inquiry was held, to which I was not aware. I was not served any notice, nor I was asked to present on the date on the inquiry. Then Lordship, based on the inquiry report, then the in-pin order was passed. The inquiry report is at page 36, Lordship, of the same counter.
Yes.
With this is they have stated the same thing, that the petitioner joined in 2001 and the respondent joined in 2000. That is why she is senior to the petitioner. As such, she should be promoted to the post of headmistress. Then after that, Lordship, based on the inquiry report, that in-pin order was passed, Lordship. The in-pin order is at page 34, Lordship, in my writ petition, Lordship. 32, sorry, 32. 34, sorry, 34, Lordship. 34.
Yes.
May I read, Lordship? As per the inquiry report number so-and-so, submitted by Sri K. Kumar Hajang, Block Mission Coordinator, this is respondent number 6, as per UDICE, which is filled by the headmistress herself. It is known that Sri Oleda Sheikh, she is the respondent number 7, is senior to Sri Moti Supia Khatun. Oleda Sheikh has joined in the year 2000 and Supia Khatun in the year 2001. Thus, based on their joining report, my lord, this is very important. Thus, based on their joining reports and appointment letter, Srimati Oleda Sheikh is hereby approved as the headmistress of Tilapara Girls SSA LP School. Therefore, Srimati Supia Khatun is hereby directed to immediately hand over all the charges to the approved headmistress, Srimati Oleda Sheikh. Now, my lord, prior to Lordship, why I am saying that there was no managing committee, Lordship? Page 33, Lordship. Since there was no managing committee, these are a private school, government is giving aid. Management, the presence of the management is very much necessary with regard to the disbursement of the salary, Lordship. That is page 33, Lordship. This is a government letter saying that the management is entrusted to the government officials, Lordship. Sri so-and-so CRC, this is Central Resource Coordinator, Kasaripara CRC, is authorized to draw and disburse salaries of the teaching staff of Tilapara Girls SSA LP School till the reconstitution of managing committee. This order will remain in force until further order. This order was passed prior to the passing of the in-pin order. That means there was no management committee at that time when the inquiry was conducted, as well as when the in-pin order was passed.
Okay. This is order dated
16/4/2014, Lordship. Now, the issue here, Lordship, first issue, Lordship. Admittedly, these are SSA school, means aided school. Government is giving aid under a centrally sponsored fund. That is,
first you say that is a private school, not government aided. Now you say it's aided.
This is aided school. And what is the definition of aided, Lordship? What is the definition of aided? Aided, as per the Meghalaya Education Act, aided means recognized private school receiving aid from the government, because the appointing authority and the termination authority, the authority to suspend, the authority to reduce the rank of any employee lies with the managing committee, and government is only the approving authority. Whatever the action is taken, unless it has to be approved by the government, the action taken by the management cannot be given effect to. Why that power is given? Just to check and balance, so that the employees of any school should not be victimized at the hands of the management. That is why checks and balance. Why I am saying, Lordship, that is that if my Lordship have Education Act, Lordship, that that is Meghalaya School Education Act, Lordship. Page will be, in the page will be,
just go to the section.
Section will be 3, subsection 1, Roman 1 and Roman 2, Lordship.
Yes.
That aid or grant in aid means any sum of money paid by the state government to any educational institution, aided school.
Yes.
Lordship, aided school means a recognized private school which receive aid in the form of maintenance or development grant from the state government or any other authority designated by the state government. Here in the state of Meghalaya, Lordship, there are few categories of school, Lordship. My Lordship is well aware. One is ad hoc, one is deficit, and now is SSA. This is also one form of aided because only the fund is receiving, they are receiving from the government, and so far as ad hoc is concerned, the state is bearing all the cost, and deficit also state. These are all aided school. Only the nomenclature is different because they are receiving aid from the government. Now, Lordship, now the issue whether my friend has raised the issue that Meghalaya Education Act is not applicable. Since this is a SSA school, that is why that Meghalaya Education Act is not applicable in SSA school. So whether his contention is right or not, I'll just substantiate my argument, Lordship. Now, in my written submission, Lordship, I have referred some judgment.
Don't refer to the written argument at this point of time. First, you go on your later. Even if you want to refer to some authorities, you can do it now.
No, I have enclosed in my all my authorities, Lordship. That is okay, Lordship. All right, Lordship. This is a judgment, Lordship, 2013 1 NS Northeast judgment. 2013 1 volume 1.
2013
volume 1.
Yes.
NEJ page 90, Lordship.
90. Para?
The relevant para will be 6.1, 6.2, 7 and 9, Lordship.
You have given the list?
List I have enclosed in my written submission, Lordship.
Even then, you should have.
I'll provide the list.
Then
I'll provide, Lordship. Since I was of the view that since I have enclosed and same copy is up to the other side.
Just a moment.
Otherwise, no difficulty. I can.
No. If it is here, I'll find out.
Yes, Lordship. page, Lordship, running page is 8, Lordship.
Oh, yes.
Running page is 8, Lordship. This is the head notes, Lordship, and the following page will be 6.1, Lordship.
Yes.
Section 1 of the Act defines aid or granting aid as money paid by the government to any educational institution. Section 3.2 defines aided school as recognized private school which receive aid in the form of maintenance or development grant from the state government. The government has reserved for itself under Chapter 2 of the Act the power to establish, recognize, manage and granting aid to recognized private schools. Section 6 of the Act provides for a scheme of management of the schools and Section 7 provides for manner of granting aid to recognized schools. The disciplinary action against employees of recognized private schools are governed by Chapter 4 of the Act, and subsection 2 of Section 9 prescribe that prior approval of the competent authority is essential for entirely terminating the service of the employees of a recognized private school. This is all about termination. Why I am saying, Lordship? Because any act has to be done by the government. It has to be done. Any act done with regard to the employees, it has to be done by the management, the access. Now, from the materials on record, it is clear that the school is receiving granting aid for salary payment of its teachers. Significantly, the Act does not prescribe any specific sum as granting aids to be paid by the state government, or any amount paid in the form of maintenance or development grants can make a private school an aided school. Under the definition section of the Act, admittedly the school where the petitioner was employed used to receive granting aid from the government. Therefore, notwithstanding the fact that it is otherwise a private school, the statutory prescription under the Act will operate in case taking disciplinary action against the employees of such school. Now, para 9, Lordship, although it might be a private school, this is as per the definition, Lordship, recognized private school. Since the school is managed by a managing committee constituted by the government and is also receiving granting aid, the statutory prescription, the Act would surely apply, and the service of the employees in such a private school cannot therefore be terminated without securing prior approval of the competent authority under subsection 2 of 9 of the Act. Next page, Lordship, page 10, Lordship.
Yes.
Relevant para will be, Lordship. This is also another judgment, Lordship. This is also 2010, Volume 2, Northeast Judgment, page 290. The relevant para will be, Lordship, 3 and 4. 3 and 4. And 4.
Yes.
3. From the affidavit opposition of the state respondents, it is obvious following the constitution of the new managing committee, the petitioner has not only been replaced as the secretary of the managing committee but has also deprived of his salary as assistant teacher. Now, so and so. In my opinion, this exercise virtually amounts to termination of the services of the petitioner or removal from his service. The affidavit opposition also reveals that this action has been taken by the respondent on the ground that the petitioner had never attended his duty and had never ever engaged some other person on contract basis to teach the school children. It is contended by Mr. E.C. Souza, learned counsel for the petitioner, that the impending action of the respondent is not only arbitrary but has contravened the provision of Section 9(2) of the Meghalaya School Education Act 1981 and Rule 4B of the rules regarding conduct and discipline of the employees of aided educational institution. At this stage, it may be useful to reproduce the provision. reproduce the provision of section 9.2 of the Meghalaya School Education Act, Lordship. 9.2 what says, Lordship? This is, they have copied from the Act, Lordship. Subject to any rule that may be made in this behalf, no employee of a recognized private school, that definition, Lordship, 3.2, recognized private school shall be dismissed, removed or reduced in rank, Lordship. Though promotion, but virtually it has reduced my rank, Lordship. Nor shall his service be otherwise terminated except with the prior approval of the competent authority. It may also refer to Rule 5 of the Service Rules of for employees of government aided schools, service rules so and so, enumerated at page 170 of the Meghalaya Education Code, first edition, which is the following terms. My lord, any of the following penalties may be imposed on an employee of an aided school by the managing committee for good and sufficient reasons. Lordship, for a moment, if my lordship is having that education code, Lordship, page 170, Lordship, what does page 170 says?
It's 170.
170, Lordship.
This is the service rule.
Service rules, yes, Lordship.
Yes.
See, service rules for employees of government aided schools. Appointment and dismissal.
Yes.
May I read, Lordship?
Please.
The managing committee of a school is the authority to appoint person in connection with the affairs of the school, and as such it is the authority to dismiss or remove such person, provided that all cases of appointment except temporary appointment for not more than so and so, removing concerning members of the teaching shall, that is not relevant, Lordship. 5 is very important because they have copied in the judgment, Lordship. 5.
Yes.
Any of the following penalties may be imposed on an employee of an aided school by the managing committee, Lordship, for good and sufficient reasons. Dismissal, reduction in rank. And none of the penalties shall be imposed on an employee of an aided school until he has been given a reasonable opportunity of showing cause against the proposed action to be taken in regard to him. Here says, Lordship, if power lies with the managing, they are the appointing authority. As such, they are the authority to take any action against the employees. When they take any action, they have to take approval from the government, that is under section 9 subclause 2, and none of the penalties should be inflicted upon the employees without giving a reasonable cause of hearing, opportunity of hearing. Here why I am saying, Lordship, I just to impress that that act is applicable, because other than this Meghalaya, that Education Act, there is nothing, Lordship. One more judgment, Lordship. This is latest 2019. Uh, 2019 SCC online, Meghalaya 1 to 2. Para will be 7, Lordship. 7 and 9, Lordship.
Seven and 9.
9.
Excuse me.
Seven is, my friend is representing the government. Mr. K.P. Bhattacharya learned GA for the respondent number 123 submits that it is a precondition that as per the rules, before a teacher is terminated or released from service, the approval of the competent authority is to be obtained. which in this case perhaps not adhere to. He further submits that in this regards the respondent number 2 had also from the respondent number 3 as regards to the manner in which the proceedings have been conducted and whether due process has been adopted, but the query was never replied to by the respondent number 3. Then the basic contention in this writ, para 9 Lordship. The basic contention in this writ petition is that whether the writ petitioner has been terminated from the service in total violation of the principle of natural justice and the requirement as contained under Section 9 of the Meghalaya School Education Act. It is also stated that in the course of submission, the learned counsel for the respondent number 4 also does not refute this contention that the proceeding adopted was not in accordance with law, though there were allegations of negligence, subordination, and misconduct against the petitioner. Then, relying on that, next para Lordship, relying on that 9.2 Lordship, that termination was set aside, Lordship.
Yes.
My friend is saying that these rules, these judgments are applicable only in ad hoc school. This is the SSA, so that rule will not be applicable. I'm just relying that latest judgment of this Honorable Court, Lordship. My Lordship has.
Yes.
I can read from para 4 Lordship. Whether the school, on the school being upgraded under Sarva Shikha Abhiyan SSA scheme, the petitioner as headmaster has also submitted a format of teacher's profile under Tikrikila block so and so. The list of the following teachers of Rongshai SSA UP school contains the name of the petitioner headmaster, and among the 5 names listed, the name of the respondent.
You are reading para?
Para 4 Lordship.
Para 4.
Yes, Lordship.
Yes.
Here just to show that in this case also, Lordship, my Lord has, relying the Meghalaya School Education Act, has set aside. That is at relevant para will be, Lordship. Para 9, Lordship. Even otherwise, the school of the petitioner being a recognized. Here in this, it is the SSA UP school, and my case is SSA LP school, Lordship. Even otherwise, the school of the petitioner being a recognized private school, the provision of the Meghalaya School Education Act is applicable, and subsection 2 of section 9 of the Act provides that so and so. My Lord copied the provision of the Act, and this provision has been violated in mass as the prior approval of the competent authority, which the district mission coordinator Dadangiri has not been obtained by the school authorities before termination of the so and so. Finally, the learned counsel for the petitioner has submitted that this court may be pleased to set aside and quash the impending termination and to direct the school authorities to reinstate the petitioner as headmaster of the school. It is also submitted that since the petitioner has not been paid the salary from the month of March 2017 till September.
This is not relevant.
This is not relevant, my Lord. 13, Lordship. Mr. R. Gurum, learned additional senior J appearing for the respondent number 126 has submitted that apparently the respondent managing committee, while passing the impending termination order, was not complied with the provisions of law as pointed out by the petitioner, particularly the provision of subsection 2 of section 9 of the Meghalaya School Education Act. However, it is also noticed that the petitioner has filed a representation number so and so. As such, it may further submitted that the attention of the respondent may be directed to the said representative and to dispose of in accordance with law. Here, Lordship, having regard submission and face of the record, the petition merits consideration as the impugned termination order was passed without affording any opportunity to the petitioner to respond to the allegation made therein. The proper procedure has not been followed by the respondent, and however genuine grounds for termination for which the petitioner may not enter into discussion, so on, so on, so my lord. Here the government has said that rule has not been followed, Lordship. They are also saying that Meghalaya school education ought to have been applied. Now, Lordship, now another issue, Lordship, whether in absence of managing committee. Now, at the time when the action was taken against me, admittedly there was no managing committee. Now, what does the rule say when there was no managing committee, or when the management of the school is taken over by the government? Rule then Section 20 of the Meghalaya School Act, Lordship, Education Act, itself provides page 35, Lordship.
Yes.
Chapter 3, this is the part of the Meghalaya School Education Act, Section 20, Lordship. Lordship, may I read, Lordship?
Yes, please.
Whenever the government is satisfied that the managing committee of any school, whether recognized or not, has neglected to perform any duties imposed on it or by under this act or rules made thereunder, and it is expedient in the interest of school education to take over the management of such school, the government may, after giving the managing committee of such school a reasonable opportunity of showing cause against the proposed action, take over the management of such school for a limited period not exceeding 3 years. Now, what happens when the management of any school is taken over? Whenever the management of any school is taken over under Section 1, every person in charge of the management of such school immediately before his management is taken over shall deliver. That is not relevant, Lordship. Now, para 3, Lordship. After taking over the management of each school under this act, the government may arrange to manage the school through any person or authorized person by the government in this behalf herein after referred authorized officer. Here, Lordship, they have appointed the authorized officer with regard to draw and disbursement of salary to the teachers. Now, Lordship, directly para 6, Lordship, very relevant, important, Lordship. During such period, when the management remains under the control of the government, Lordship, the service conditions as approved by the government of the employees of the school who were in employment immediately before the date on which the management was taken over shall not be varied to their disadvantage. Here, Lordship, there is a bar. They cannot do anything when the school is under the government, when there was no managing committee, when there is no managing committee and the school is managed by an authorized officer of the government. The government on its own cannot do anything against the employees because they are only the approving authority. Whether the power which has been assigned to the managing committee can be exercised by an authority who has only given the power to approve. He has exercised discretion either to approve or reject, but he cannot usurp the power which need to be exercised by the managing committee. The rule says that there is a bar, statutory bar, that they cannot do anything when the school is run under the management of the government. My lord, I have, with regard to that power lordship, whether they can exercise the power during that period. So I am referring to judgment of the Delhi High Court. Our Meghalaya Education Act is a replica of the Delhi Education Act, lordship. Everything is same. There is little bit of modification, only the nomenclature, lordship. The rest is the same, lordship. Here, lordship, that is at page 17. I am referring that SCC online, lordship, 1996.
Just on page
1996 SCC online.
No, page.
Delhi 74, lordship. In my written argument, page 17, lordship.
74.
17, 1, 7, lordship.
Yes.
The relevant para is 10, lordship.
Then
here also promotion was granted by the government. May I read, lordship? In order to resolve the issue raised in this writ petition, it would be appropriate to examine the legality and or the validity of the order of promotion issued by the education officer on 17 to 1975, promoting the petitioner to the post of PGT Hindi, inasmuch as the petitioner has relied on his order of promotion for his challenge. The subsequent action on the part of the respondent keeping the aforesaid order in abeyance. Here in this case, what happened, lordship? The promotion order itself was issued by the officer, government officers. Then later on, that same order was kept in abeyance by the same authority. The petitioner in this case, he has challenged, saying that no, the government cannot revoke that. It is the authority, the managing committee is the authority. Then my attention has been drawn to the provision of Rule 98, according to which every appointment made by the manager of aided school shall initially be provisional and shall require the approval of the director. A careful reading of the aforesaid rule makes absolutely clear that all appointments of aided school have to be made by the managing committee, but the same requires an approval which is to be obtained from the director. In the instant case, the order of promotion in respect of the petition is issued by the education officer, whose action in the light of the provision of Rule 98 appears to be illegal and without jurisdiction. The director can only give an approval to the proposal submitted by the managing committee in respect of the intending promotion, but no such promotion in respect of the teachers of an aided school could be passed by the director or any officer subordinate to him of his own. They cannot do, lordship.
Yes.
Lordship, then another judgment, lordship.
On the same issue?
Same issue. That is when the school is taken over by the government, whether they can. Uh, 1992 SCC online, Delhi, 182, lordship.
Yes. Para?
There is no para. In fact, this is, they have not mentioned any para, lordship, here.
Page?
Page will be 26, lordship. Running page 26.
Yes.
Yeah, lordship. Under section 8 of the Act, here we have 9, lordship. In Delhi, what we have 9, here they have 8.
Parametria.
Parametria, lordship. The administrator is empowered to make rules regulating entirely the condition of service for employees of recognized private school. Subsection 4 of section 8 provides that where the management of any recognized school intend to suspend any office employee, such intention shall be communicated to the director and no such suspension shall be made except with the prior approval of the director. Subsection 1. This is I have highlighted, Lordship. Here it says that legal position emerging from the statutory provision of the Act that the rule is carried with regard to the authority, the procedure and the circumstances in which the suspension on employee of a recognized school can be made. The basic power to place an employee under suspension is conferred upon the managing committee of the school. The exercise of the power is controlled by the requirement of approval of suspension by director on his satisfaction that there are adequate and reasonable grounds for such suspension exist. The director has no power, authority or jurisdiction himself to make an order placing an employee of any under suspension. They cannot. The power to place an employee under suspension can be exercised only by the appropriate appointing authority and by no one else without express authority to do so. Now here, Lordship, section 20. 20, here the same, they have exact quotation they have kept, Lordship, they have just copied it from the Delhi Act. It may also be relevant here to point that section 20, which I have referred earlier, Lordship, of the Act provides for taking over the management of the school whenever the administrator is satisfied. Administrator means government, Lordship. In our Act, it is mentioned appropriate government. Satisfied that condition invised under the section are fulfilled. Whenever the management of any school is taken over, the person in charge of the management of such school is bound to deliver. Now the interpretation of this section is down, Lordship. The last paragraph below, Lordship. The aforesaid provision expressly made in clause D of subsection 6 of section 20 of the Act indicates beyond doubt intention of the legislature neither to supersede the managing committee nor to divest it of its power and function of the appointing authority vis-a-vis employees, nor to transfer the power of the managing committee to be exercised directly by the director. As such, even when the management of a school is taken over under section 20 of the Act, here also 20, our Education Act also 20, Lordship, the director gets no authority exercisable by the appointing authority vis-a-vis the employees of the schools under the Act or the rules. Here says, Lordship, same which I have explained earlier, Lordship. Yes. Now, Lordship, so far as the issue of applicability of the Act as well as the power of the government with regard to the employees of the school, I have highlighted, Lordship. Now in the counter, Lordship, in the impugn order, it is very clear. It is said that based on the seniority, I joined 2021 and the respondent joined 2000. She is senior to me. That is why her promotion was granted. That is the reasons given in the impugn order, Lordship. But the government, in their counter affidavit, Lordship, they have supplemented some grounds, Lordship, which are not relevant. Now, with regard to the issue, whether they can supplement some grounds by way of affidavit in order to justify their action, Lordship. So I am relying Lordship, 2021, page 29, Lordship.
Yes.
2021,
Yes.
6 SCC 707, Lordship.
Yes.
The relevant para would be 12 and 14, Lordship. 12, first I read 12, that is running page 36, Lordship, in my 36, Lordship.
Yes.
Now the action sought to be sustained, para 12, Lordship.
Yes, yes, please.
Should be sought to be sustained should be with reference to the content of the impugn order communication, and the same cannot be justified by improving the same through the contention raised in the objection statement or affidavit filed before the court. This has been shockingly laid down by this court. This is a full bench constitutional judgment, Lordship. Mahinder Singh Gill versus Chief Election Commissioner as follows. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavit or otherwise. Otherwise, an order that in the beginning may, by the time it comes to court on account of a challenge, gets validated by additional grounds later brought out. We may here draw attention to the observation of both so-and-so. Public orders publicly made in exercise of statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant or of what was in his mind or what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to effect the actings and conduct of those to whom they are addressed and must be construed objectively with reference to the language used in the order itself. Orders are not like old wine, becoming better as they grow older. Now, Lordship, para 14, next please, Lordship. This court has time and again emphasized that if a institute provides for a thing to be done in a particular manner, then it has to be done in that manner alone and in no other manner. Amongst other, in a matter relating to the presentation of an election petition, as per the procedure prescribed under the Patta High Court rules, this court had an occasion to consider the rules to find out as to what would be a valid presentation of an election petition in so-and-so. Para down, Lordship. 17. It is well settled statutory principle that if a statute provides for a thing to be done in a particular manner, then it has to be done in that manner and no other manner. Therefore, if the salutary principle is kept in perspective, in the instant case, though the authorized officer is vested with the sufficient power, such power is circumscribed by a procedure laid down under the statute. As such, the power is to be exercised in that manner alone, failing which it would fall of the requirement of complying with due process under law. Here also, Lordship, the power is given otherwise, just to approve. Now they have issued the power of the managing committee. That action is illegal. Now another aspect, Lordship. I was appointed in 2001. She was appointed in 2000. Now all throughout, Lordship, she did not raise any objection. In the affidavit, they said that we have raised objection. What prevented the respondent not to challenge at that relevant point of time? Now after 15 years, Lordship, whether is permissible, even for promotion also, Lordship. So with that issue, Lordship, I'll just rely on as 2010 12 SCC Lordship.
2010
12 SCC 471. Running page, the judgment is at running page 40 Lordship. Para will be Lordship. I am referring few paras Lordship in this case. 18, 19, 21. 18, 19, 21, 22, 23, 25, 29 and 30. Running page is at 40 Lordship.
Yes. Just tell me the gist of this judgment.
Gist Lordship here says that for promotion Lordship, they cannot come after a long time Lordship. They cannot come because there is a limit Lordship. They cannot.
So delay, principle of delay.
Yes Lordship. With regard to that issue, I am referring to judgment Lordship. That down below, Tarsem Singh also is there. Here I am referring only one para 7. After 15 years, they cannot come and say that no, I am senior, I should be promoted to the post of headmaster, and she should be downgraded to the post of assistant research, which neither the act nor the judgment of the Honorable Supreme Court Lordship permits for doing so Lordship.
This is 2008.
2008 Lordship. The relevant para is 7. These two judgments I am referring with regard to delay claim of promotion Lordship. Now, my Lord, he has referred in his written submission that the applicability of the Meghalaya, my friend can submit, after that I can just clarification Lordship, that government can. Not here.
Please, Lordship, I'm appearing for respondent number 7, private respondent.
You are? Okay, well, you are.
Only that, yes, Lordship. Here what happened, Your Lordship, why the delay and previous representation has been sent to the managing committee, Your Lordship. It happened, Your Lordship, since the year 2002 till 2014. The managing committee was run by the father, the uncle and the mother of the petitioner, Your Lordship. That's why all my grievances or letters sent in 2001, 2002, 2005, this meeting taken up. After that, we have written directly to the government authority. After that, inquiry has been made, and based on that, Lordship, the impugning order was, which the challenge has been made, Lordship. The main problem is that the action has not been taken for so many years because the president here, Your Lordship, is the petitioner's father, managing committee. Then the vice president, petitioner uncle. Then this the donor member, petitioner mother. Since when the managing committee expires, Lordship, any managing committee comes, same member only, Your Lordship. That's the main problem regarding the delay, Lordship. It's not that intentionally I'm not aggrieved. It's that the managing committee has been run by the family members of the petitioner only, Your Lordship.
Yes.
Regarding the other aspect regarding the inquiry and all, Lordship, the state, my limited only to that, Lordship. I've written since 2001 to the managing committee. No action, the matter has not been taken up just because the managing committee has been run by the family members of the petitioner. Then I've written a representation to the state.
But have you have written to the managing committee? They could be family members.
Yes, Your Lordship.
You have written.
Yes, Your Lordship. I've annexed.
You have annexed that in your
affidavit, Your Lordship, in annex.
And have you got any response to your?
No, Your Lordship. No action taken. No nothing.
not forwarded to the, it's only after I've written to the, when the managing committee has been taken up by the state government, it's there only, Your Lordship, in 2014 that 2016 that the matter has been taken up by the state government. Otherwise, by the managing committee, it's not been taken up for many years, Lordship. That's the main reason, Your Lordship. Your Lordship, regarding the others, the inquiry and all has been conducted by the state authority after they had taken up the school. We replied with the state.
So your submission is only limited to
yes,
that?
Lordship, because I joined in 2000, FDC joined in 2001. I've written many representation, but because the members of the managing committee are all family members, they did not forward my representation, did not taken up. It's only 2014 when the managing committee has been taken up by the state authority, then the matter has been taken up. It's a fact that I've joined in 2000, that decision joined in 2001. They also admitted it. And in the USIC record, national record also, Your Lordship, is reflected that I joined in 2000.
Oh, that is not denied.
That is not.
Yes.
My Lord, here, my Lord, the petitioner over and again is stressing on one thing, my Lord, is that he's, Lord, the guided rules will be the Meghalaya Education Act. My Lord, why he's stating so, my Lord? Because that benefits him. But my Lord, my respectful submission, my Lord, it is not. My Lord, the very purpose of SSA, my Lord, Sarva Shiksha Abhiyan, my Lord, it came into existence, my Lord, under the right to education, free and compulsory education to all, my Lord. My Lord will see, before I go into further argument, my Lord will kindly see the area of parties in the writ petition. My Lord, in the writ petition, my Lord, the block mission coordinator is there. This is respondent number 6. Then the joint district mission coordinator is there, which is respondent number 5. Then we have respondent number 4, the district mission coordinator, my Lord. So, my Lord, these area of parties, then the state project director, my Lord, these are directly related to the SSA, my Lord, Sarva Shiksha Abhiyan. Now, my Lord, what does the Act say, my Lord? So, may I take, my Lord, attention to the Act, my Lord?
RTE.
RTE, my Lord. Right of Children to Free and Compulsory Education Act. Because, my Lord, the petitioner is banking primarily on Meghalaya School Education Act. He has, I am surprised that he's not made a single whisper about the right to Children Free and Compulsory Education Act or the RTE rules, my Lord.
Yes.
My Lord will kindly see, if I take, my Lord, to chapter 3, section 6, my Lord, that is duty of appropriate government and local authority to establish school.
Section?
Section 6, my Lord, of the right of Children to Free and Compulsory Education Act 2009.
Yes.
So, my Lord, what it says? Duty of appropriate government and local authority to establish school.
Yes.
For carrying out the provision of this act, the appropriate government and the local authority shall establish within such area of limits of neighborhood as may be prescribed a school where it is not so established within a period of 3 years from the commencement of this act. So the duty is cast upon the government, my Lord, or on the state authorities as well as the local authorities to set up schools, my Lord. Now these schools are set up for whom, my Lord? For the children, so that, and more so the underprivileged children, to provide them free and compulsory education, my Lord. Then number 7 is, my Lord, sharing of financial and other responsibilities.
Yes.
The central government and the state government shall have concurrent responsibility for providing funds for carrying out the provisions of this act. So, my Lord will kindly see, what is SSA? If a SSA school is established, what is the guiding principle?
The power comes where, my lord?
Sorry to interrupt you.
My lord.
Is there any difference between SSA schools and government aided school?
Yes, my lord.
They are different.
They are different, my lord. The government aided schools are directly under the deficit grant, my lord.
Yeah, they are getting grant in aid and
yes,
all those things.
In my respectful submission, my lord, this is a self-contained act. The SSA schools are not borrowing anything from the Meghalaya School Education Act, my lord. Even, my lord, for that matter, even if the teacher has some grievances, my lord, if I take, my lord, to, my lord, section 21 of the Right to Education Act speaks of about the managing committee, my lord. Because if there was only the Meghalaya School Education Act was the guideline, my lord, then there should not have been any provision for managing committee stated here, my lord. Why do you have to have a separate provision for school managing committee? Then we should have gone by the Meghalaya School Education Act.
Yes.
School managing committee, if I'm allowed to read, my lord. A school other than a school specified in subclause 4 of clause N of section 2 shall constitute a school managing committee consisting of the elected representatives of the local authorities, parents or guardians of children admitted in such schools, and teachers. So, my lord, these are the how it is to be constituted. This is mentioned, my lord. Now, my lord will kindly, my lord, if my lord kindly goes to section 23, my lord, of the Act, RT Act.
Yes.
Qualifications for appointment and terms and conditions of service of teachers. So, this is also stated in the RT Act. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So, these are the criteria, my lord. Where a state does not have adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualification as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualification. So this is as for, my lord, so this lays down then what is supposed to be the qualification of the teachers. Now, my lord, section 24 deals with the duties of teachers and redressal of grievances. So, my lord will kindly take note of that particular word, redressal of grievances, my lord.
Yes.
So, if I am allowed to read the whole section, my lord. A teacher appointed under subsection 1 of section 23 shall perform the following duties. So, my lord, these are the A to F, my lord, these are the duties which a teacher is supposed to perform, my lord. Now, subsection 2, what it says, my lord? A teacher committing default in performance of duties specified in subsection 1 shall be liable to disciplinary action under service rules applicable to him or her.
Applicable service rules.
Now, my lord, provided that before taking such, so my lord, the only benefit which the petitioner in my respectful submission would be entitled is that, my lord, that if there is any action taken, reasonable opportunity should be provided. That is the only case, my lord. Provided that before taking such disciplinary action, reasonable opportunity of being heard shall be afforded to such teacher. 3. Now here comes grievances, my lord. The grievances, if any, this is the grievance of the teacher, apart from all that. The grievances, if any, of the teacher shall be redressed in such manner as may be prescribed. So this is the redressal, my lord. Now, my lord will, I may take my lord's attention to the rules, my lord. The Meghalaya, my lord, this is Meghalaya Right of Children to Free and Compulsory Education Rules, 2011.
11 or 10?
2011, my lord. This is the rule of the state, my lord, state of Meghalaya. My lord, here several things are laid down, my lord. How recognition is granted, when recognition may be. So, section 11 deals with the recognition of schools for the purpose of section 18, my lord. So, how recognition, this is, I am referring to the rules at the moment, my lord, not the act.
Here in the
This is RT Act, my lord, but the state of Meghalaya has its own rules also. Certain rules have been framed, my lord. That is dated 2011, my lord. Meghalaya.
Meghalaya.
Yes, my lord. The Meghalaya Right of Children to Free and Compulsory Education.
Yes, sir.
Rules 2011.
We don't have a copy of that. Apana, please. If you have a copy, extra copy.
Unfortunately, I don't have, my lord, but I can give the copy to the court, my lord.
Just point out,
my lord.
Point out what you have to say.
Similarly, my lord, section 15 speaks of minimum qualification. 7 is, my lord, 15, 16 deals with relaxation of minimum qualification. Now, grievance redressal mechanism, my lord, is at 20. Salary and allowances are guided by section 18, my lord. So, my lord will kindly see, my lord.
Yes.
Grievance redressal mechanism. My lord, who are the authorities? First, for any grievance redressal is, my lord, is the school managing committee constituted under section 21 shall be the first level of grievance redressal of teachers of school specified therein. Second, my lord, the state government shall constitute school tribunals at state, district and block levels which would act as grievance redressal mechanism for teachers. These are, has he taken any such plea, my lord? He has not taken any such plea in the writ petition. So, my lord will kindly see, my lord. These are the two grievances. So, my lord, even then this writ petition is premature, my lord. My lord will kindly see. The alternative remedy is already there. But because
here he says that there is no school managing committee.
No, my lord. First, in grievance redressal, my lord, 2. The managing committee, yes, understood. Understood, there is no managing committee. Then who is the next? Did the petitioner try to find out whether there is a tribunal or not?
Is there?
Is there any averment in the writ petition?
Is there a tribunal?
My lord, at this juncture, of course, I am not sure, my lord. But this is what the law says. This is the first research that the petitioner should have done, my lord. If as far as the tribunal is concerned, I can find out from the state, my lord. But this is the first ground that he should have looked into before prior to filing the writ petition.
Yes.
No, my lord, the petitioner has stressed that the managing committee is taken over by the government. My lord, is it so, my lord? What it says? Because the petitioner placed reliance on, my lord, annexure A7. This is letter dated 16/4/2016. Now, what the order says, my lord, if I may read the language of the order. Shri Abdur Rahman Sheikh, CRC coordinator, Kashibari CRC, is authorized to draw and disburse salaries of teaching staff of Dilapara so and so till reconstitution of new managing committee. This order will remain in force until further order. My lord, where does it say that the managing committee is taken over? Where does it say? Does the language say, my lord, that the managing committee is taken over by the government? The simple language is, my lord, as far as the disbursement of the salary, power is given to so and so person. Nowhere there is a whisper, my lord, that the managing committee has been taken over. Now, my lord, now comes to the question of the managing committee, my lord. Now, the managing committee, my lord, several opportunities were given. They have not constituted. Government has merely given a power to such a so and so person, so for the disbursement of the salary only. But otherwise, the staff or the teachers who are teaching there, how are they supposed to get their salaries? So this is only for a restricted purpose of disbursement of salary, nothing else. And whom the authority is given? It is given to Abdur Rahman Sheikh, CRC coordinator. So, my lord, if even assuming rightly and wrongly, if there is an inquiry done, my lord, is he the same person sitting on the inquiry? Who is he? He is the CRC coordinator. So, my lord, the very submission that the management is taken over, my friend has been harping on this since the beginning. Management taken over, it's not taken over. It says still constitution of further, till a fresh managing committee comes into existence. Only the disbursement is charge is being given to someone else, nothing else.
See, in that event,
My lord,
what empowers you to, to elevate the respondent number 7 and demote the petitioner? That
my
was
lord,
done through
my
the
lord,
authority.
if a petitioner has a case, my lord, on ground of, my lord, principles of natural justice, or my lord, a reasonable opportunity should have been given to the petitioner, petitioner may have a case, my lord. But my lord, the petitioner harping that it is Meghalaya School Education Act and he's relied on several judgments, in my respectful submission, my lord, none of them are applicable. Yes, principles of natural justice, petitioner may have a case, my lord. But to say that, my lord, not to whisper about right to Free and Compulsory Education Act or the education rules, you give a complete go-by to that and you say my case, I rest my case on Meghalaya School Education Act and its applicability. My lord, in my respectful submission, the contention of the petitioner has no legs to stand, my lord. These are self-contained, these are two separate legislatures, my lord. This is a total different thing, my lord, because the purpose is to provide free and compulsory education, my lord. And the deficit school guidelines, they are not exactly the same, my lord. Even the running of the managing committees. Now here the managing committees, if I am not mistaken, for a period of 2 years. In the deficit schools, it's for a period of 3 years, my lord. The several differences are there.
UP also, this UP also 2 years.
You give your submission when you have to give. But my lord, my contention is that petitioner is harping his case. Harping his case on Meghalaya School Education Act, in my respectful submission, that will not be applicable because these acts itself are self-containing, my lord. Secondly, my lord, as far as the grievance redressal is concerned, it is very clear. Now let's assume there is no managing committee, fine. Petitioner ought to have found out whether there is a tribunal or not, state set up tribunal or not. Petitioner could have gone forward with her complaints. That has not been done. There is no whisper in the writ petition wherever or anywhere stating that she has exhausted all remedies and then thereafter she has approached this honorable court. So, my lord, in my respectful submission, my lord, this writ petition is premature. The contentions which are raised in the writ petition, petitioner should seek alternative remedy which is there. It is open for the petitioner to seek alternative remedy. If the petitioner finds out there is no alternative remedy, then maybe she can approach this honorable court, my lord. And my lord, in principles of natural justice, she may have a case, my lord, but not otherwise. My lord, this is my limited submission. And as far as, my lord,
even on that point, the whole case revolves on that.
My lord,
if she has not been afforded,
so my lord,
if she has not been afforded, an opportunity of being heard, whereby the impugned order was passed, then naturally.
My lord, because impugned order was, my lord will kindly see, because my friend has also for a private respondent number 7 had already submitted before this honorable court that, my lord, the managing committee for the more than 12 years was being managed by petitioner's family only. My friend has candidly stated that she has made several representations. It was never paid heed.
That will have no bearing on the.
My lord. Now, only thing is that, my lord, the rightly or wrongly, my lord, the order was passed, but it was based. Lordship will kindly see. Even the inquiry officer or whoever has passed this order, my lord, has passed on the basis of the record, my lord. Yes, I understand. Perhaps a show cause notice should have been issued, but it was primarily based on record, my lord. So, if the order was otherwise, it was passed in bona fide good faith, my lord. There might have been some problems, but that is all I have to say, my lord. It is not intended.
Nothing has been demonstrated in that regard.
But primarily because in our affidavit we have stated that it is a part of on the basis of the record we have passed. Now, my friend is saying that affidavit cannot.
What has been passed is, as has been stated, is only on the basis of the inquiry conducted by you.
Yes, my lord.
So you have passed it.
Yes.
But again, we come back to the same point.
My lord, at best there could be a direction for. Firstly, my lord, if my friend overcomes the other because I am challenging that, saying that, my lord, this is writ petition itself is premature. But even assuming, my lord, if this is entertained by this honorable court, my lord, there may be a direction to conduct a fresh inquiry, giving chance to the petition. So for the time being, I rest my submission here.
My lord, can I pray for only? I'll just, with regard to that that RT Act, lordship, I want to give submission. Can it be taken tomorrow, my lordship, only? Tomorrow I'll not miss.
Mr. Sheikh, if your grievance is on the, as has been observed, or as has been submitted, that your right to be heard has not been accorded to you. The impugn order was passed without finding any, giving you any show cause notice, so on and so forth. On that ground, this court can decide the matter. Firstly, as Mr. Bhattacharjee has submitted, you have to first ensure that alternative remedies has been resorted to or not. If there are,
I have filed representation on record.
So you have filed?
Yes, because they are not. Now, my lord.
So, and number two is again, as has been conceded by the state respondent, perhaps the impugn order can be set aside. Opportunity will be given to the authorities concerned to take necessary steps, file a show cause notice, let you allow you to respond, and so on and so forth.
My lord, only one clarification. My friend is, can it be taken tomorrow so that I can, with what he made the submission, lordship, with regard to the RTE and the service rules. Everything, every employee has their own service code service rules, lordship. That has came in 2011, lordship. 11. I am not saying that that is not the service rules for employees of government aided school. The service rules for government aided school is in the Education Act code. So
that is for schools under the RTE Act, under the where the SSA scheme is implemented. Your school is where the SSA scheme has been implemented.
My lord will kindly appreciate one thing. From class 6 to class 12 is irrespective of whether it is a government school, whether it is a deficit school, whether it is a ad hoc school, that RT is applicable to all. RT is different, lordship. My service code is different, lordship. Now what my friend is saying, that RT rules, the management is constituted under 2 years. Under RT rule only SSA. No, lordship. In the deficit upper primary also, I can show, lordship. In the deficit upper primary also, the managing committee are constituted under under the RT rules. Rules is different, service code is different, lordship. In the SSA, in the RT rules, they are nowhere says that if you take any action against any managing committee, you have to follow these rules. Says that as may be prescribed by the government. The prescribed by the government means this is the rules, lordship. As may be. Nowhere says that.
Fine. So tomorrow?
Tomorrow, lordship, I'll just
let it come up day after, my lord. Tomorrow I might have some difficulty.
Parties have been heard substantially. However, on prayer made by the petitioner to reply to the argument advanced by the legal counsel for the respondents, for which some time is sought for, the prayer is allowed. This is matter on 23rd.
Will not miss the date, lordship, on that day. So we'll try to miss. Hello.
Second call, item number 6.
May I please, your lordship?
personally indisposed on ground of health conditions. As prayed for, this is matter 3 weeks.
Worship Lordship. Second call, item number 16.
Not objected to by petitioner.
Worship, the connecting counsel is coming. It's just outside.
My lord, this matter relates to denial of seniority and promotion of my junior to a higher post of a LTA. May I start or commence in the second half, Lordship? It will take some time, my lord. Lordship, I can come.
Yes, Mr. Khan, you are ready?
Lordship, we are ready. Lordship, if I may just submit, very limited issue. So far state is concerned, Your Lordship. Only issue, there was a time frame given of 30 days. And our stand is this, during that period, they chose not to file any objection and I waived the period. So once that is over, Your Lordship, whether do they have a cause of action? That is the only stand of state in the affidavit.
No, have you preferred any, representation?
My lord, it is not, appeal is not required, my lord.
No, representation?
Representation, my lord. Within that time, no, we raised the objection orally. My lord, the rule doesn't say that in writing it should be objected, my lord. So that is one of the limb of the argument of state respondent.
It would be prudent, in this day and age, it would be prudent to, reduce everything in writing.
Therefore, my lord, we raise an objection. Petitioner raised an objection regarding this, not in writing. Not in writing.
That is
and the
why
rule, my lord, the rule doesn't command.
The rule may not say so. The rule may not say so. And you have said that you have done it orally.
Yes, yes.
But like I said, you see, it would be prudent for you in this day and age to reduce everything or any objection you have a complaint in writing.
But that will show the conduct of the parties, madam. I'll show, but I'll satisfy. Once we start the hearing, madam. May I open the writ petition? That is one of the limb of the argument raised by EAG.
Lordship, so that is the only argument. You just want to waste the court's time. Lordship, you just come to page 4. I'll just satisfy only on that. The rest you can argue, Lordship.
No, this is not my proper. We are the writ petitioner. If Lordship allow us, we will proceed. The respondent cannot just proceed further.
It's okay. I'm just saying, Lordship.
He'll respond. He'll respond.
Our only stand is
that. I can proceed even now also.
So we'll take it up in the second half then?
Second half also, okay.
Please, if you can accommodate maybe then tomorrow, please. Slide. Oh, sorry, Your Lordship. Day after, Lordship, please.
Not tomorrow and day after tomorrow. We have to division bench matters.
Burnett.
Then after a week then.
Lordship, after.
Retiring very soon. Anyway, why not?
Thursday, otherwise, if it's in hurry, Lordship, Thursday also we can accommodate, no issue.
Thursday I have some difficulties. I have some matter in the court. High Court.
So 1 week then.
What?
1 week.
On pre-made with parties, this is matter to 1 week.
Supplementary cause list, item number 1.
Please, Your Lordship.
Before my friends that I also file a caveat. I'm filing a caveat.
No, you file a caveat.
Right.
You are?
Lordship, we've already filed the petition. It seems they filed a caveat after the petition was filed.
It was filed today, I think.
Doesn't matter. They are here. They will accept notice and that's
I
as
can
good
start,
as.
Your Lordship. Lordship, what has happened here is the petitioner herein is the CM of Hima Langrin. He's been functioning as an acting CM, and thereafter he was elected also by the general public by a process of elections in 2016. So he's been continuing to function as a CM till date. Now what has happened is that now recently the complainants, the respondents herein, who's a Seng Samla, they have filed a complaint against the CM, alleging many issues therein, pertinently with regard to the money which he had received in respect of the land acquisition and the donations that he's made to several other churches in Langrin Simship. Now, when the complaint was filed, what the District Council did was that, by an order dated 18/7/2023, Your Lordship, I'll take Your Lordship to that order. Annexure 4, Your Lordship, page 90.
Yes.
In the matter of alleged financial irregularities within Langrin Simship, whereas the Singh Samla, Hima Langrin and others had filed a complaint that there is a gross financial irregularities with Langrin Simship, whereas in order to prevent any further loss to Langrin Simship, the Executive Committee deemed it necessary to take remedial steps. Therefore, in the interim, the CM of Langrin is hereby directed that any utilization or withdrawal of funds by the CM of Darbar above 25,000, Your Lordship, has to be obtained prior approval from the Executive Committee, KHADC Council, Your Lordship. Then I was instructed to furnish office the detailed statement accounts. Now, when this order was passed, without hearing me, we were ordered to file a show cause also to the complaint. Now I'll take Your Lordship to the complaint. Those were the allegations. Now can we see who has signed the complaint at page 40, Your Lordship? I'll just take first to this one particular person. Complaint, page 40.
Mr. Lambri, before we proceed, this order, Annexure 4, was passed on 18th July.
Your Lordship.
It was passed ex parte.
Your Lordship.
On coming to know of it, have you,
I'll come to that. I'm coming to that, Your Lordship. Thereafter, I was directed to file my bank's the statement of account and a show cause to the complaint. Firstly, I'll take to page 40, Your Lordship. Who is the signatory? Page 40, Your Lordship.
Is it?
Number 1, Bolwester Semyong. Kindly mark, Your Lordship.
These are complainants.
Yes, page 40. Yes. Number 1, Mr. Bolwester Semyong. Because he's a very prominent figure, Your Lordship, in Langrin Simship. Now, Your Lordship, after the complaint was filed, they passed an order 18/7. We were directed to file show cause. We filed our show cause. Now, in the show cause, we have denied all the allegations. Now, firstly, I'll take Your Lordship to page 92, Annexure 6.
Yes.
Your Lordship, this is the letter from the petitioner. In inviting reference to subject cited above, I, the undersigned, begs to state that I am on receipt of your letter 26/7/2023, whereby I have been directed to file my show cause to the complaint dated 5/7/2023 within 7 days and to furnish statement of accounts fund of the Langren Aimship. It is stated herein that I, the undersigned, craves leave to fix a date to be heard in person or through an advocate after a show cause has been filed. In view of the above, today the 31st January, I am furnishing the statement of accounts, fund of Langren Aimship, and my show cause to the complaint will be filed on or before 2/8/2023 as contained in your letter dated 26/7/2023. Here we've made a specific pleading before them that we will be allowed in person at the time of hearing of the complaint. Thereafter we file the show cause. That is at page 96. Page 96, Your Lordship.
Yes.
We have denied all the allegations. That is Annexure 7, Your Lord. Now, Your Lordship, after we file a show cause, we were waiting a response that they will call us for a hearing so that the complaint may be heard. Suddenly, on Friday 18, in fact, we received the notification suspending me was on Saturday morning at noon. We received saying that I've been suspended under Rule 7. Now, Your Lordship, I'll take Your Lordship to page 27 of my writ petition, page 27, Annexure 1.
27 is Annexure 1.
27, Section 7.
Yes.
I'll come to the suspension order, Your Lordship. Now, 7, Your Lordship, term of office. There shall be only one CM to be elected from the whole Langren Aimship, and his term shall be for life, and the date of his appointment, provided that he may be removed from office or suspended by the Executive Committee if. Now, Your Lordship, I'll take to page 28. Kindly have a look at the proviso, Your Lordship. First proviso.
Yes.
First proviso says, provided further that 1. Any complaint against the CM should be brought to the knowledge of the Darbar Hima.
Yes.
And 2. The CM shall not be removed from office or punished with suspension unless he is given an opportunity of being heard. Now, Your Lordship, the suspension order is at page 132. Translated copy. This is to notify the entire Langren Aimship that since the Executive Committee, Khasi Hills Autonomous District, has suspended the functions of Sri Nangtai Singh Semyong as CM of Langren, as such as per powers conferred under Section 7, which I have read, Your Lordship, of the Khasi Hills Autonomous District Nomination and Elections of CM, Deputy CM and Headman of Langren Aimship Act 2007, is hereby pleased to temporarily appoint Sri So-and-so as acting CM of Langren Aimship and to look after the affairs of this Aimship. And now I have been suspended under Section 7. Now Section 7 says that provided I cannot be suspended, the first thing is that the complaint has to be placed before the Darbar Hima.
Before my friend goes ahead, I think this proviso has been deleted. My friend is not aware. This has been deleted, the proviso to Section 7. So
that I'm not aware, Lordship.
I can.
Even on that count, let me proceed, Your Lordship.
307. No, I just wanted to point out because there's no.
Anyway, that you will have your
Yes.
opportunity.
307.
Anyway, please continue, Mr.
Now, Your Lordship. Now the complaint was not placed before the Darbar. Now I've been suspended without hearing me. Now an act has been framed, and there's a rule also to this effect. Now that rule says, Your Lordship, that is at Three two. Take out. Firstly, I'll read paragraph 16 of my writ petition, Your Lordship. Paragraph 16.
Yes.
The petition states that the complaint dated 5/7/2023 ought to have, in the first instance, been placed before the Executive Darbar of the same ship for deliberation as contemplated under Proviso Rule 3.2 of the Langren same ship, First Amendment Rules 2015. The Proviso Rule 3.2 of the Act provides as follows. Your Lordship, I have given.
This is what you have read. This.
That is the Act. That is in the Act, Lordship, Section 7. Now,
Section 7.
This is the rule. I've read, Your Lordship, page 352, which I placed the book just now, the Langren same ship rules. Page 352.
Yes.
Amendment to Rule 3.2 of Rule 2010. In the existing Rule 3.2, a new sub-rule 3.2(9) be exerted with the following, namely, the Executive Committee, in due consultation with the HIMA, determine and notify the number of polling. That's not relevant, Your Lordship. In the existing Rule 3.2, a new proviso shall be inserted with the following. Provided that any complaint against the CM or acting CM, or before any action is taken, should be first brought before the Darbar HIMA for necessary discussion and decision. And as such, the Darbar shall be convened and presided over by the Deputy CM or any member elected by the member present in a meeting in case of his absence. However, the rule also provides that the complaint ought to have been first brought before the Darbar HIMA.
What are these rules?
This is called the Administration of Langren same ship rules, Your Lordship. Rule 3.2.
Yes.
Now, evidently it's clear that neither Section 7 nor the rule has been followed, that the complaint should be placed before the Darbar. Now, this statutory provision, the Act and the rules were framed by the District Council, and these are their rules and their Act, and they themselves now are violating the same, instead of complying to the same. Now, secondly, Your Lordship, is before appointment of any acting CM, there should be a recommendation from the CM's clan. And now, in this instant case, that also has not been complied with. Now, I'll read, Your Lordship, page 15 of my writ petition, which I have reproduced, Section 9, page 15 of my writ petition.
Yes.
Section 9 also, page 15. The entire provision I have reproduced herein. If at any time the office of the CM becomes vacant as a result of death, resignation, retirement due to old age, removal or suspension, any adult male belonging to the CM's clan or Langren CMship duly recommended by the CM's clan to function as an acting CM who shall exercise all powers and function of the CM. No acting CM shall be appointed without the recommendation of the CM's clan. Your Lordship. So, my humble submission is that there should be a recommendation before appointment of any acting CM. The CM also has not been complied with. Now, in a similar case, Your Lordship,
Yes.
I'll take Your Lordship to page 135, Annexure 11, the last annexure, Lord. Page 135. This is with regard to the same petitioner.
Yes.
The same CMship, Your Lordship. I'll read the second paragraph. Heard so-and-so, learned senior counsel assisted by so-and-so, learned senior counsel appearing for the petitioner. So-and-so, learned senior counsel assisted by so-and-so, all these parties were represented, Your Lordship, even the private respondents. Issue notice returnable within 3 weeks. No formal notice needs to be issued as the respondents have already entered appearance through their respective counsels. So-and-so, learned senior counsel appearing for the petitioner contend that to avoid the multiplicity of proceedings and also not to make their present writ petition infructuous, an interim order is called for. Accordingly, learned counsel appearing for the parties are allowed to address this court regarding the interim order. Mr. So-and-so, learned senior counsel appearing for the petitioner contended that the appointment of acting CM is contemplated under Section 9 of the Khasi Hills Autonomous District Nomination and Election of CM, Deputy CM, and Headman of Lawrence CMship Act 2007, or in short, Act of 2007. He also contended that the original Section 9.2 had been amended later on. For easy reference, the amended 9 of the Act 2007 is quoted herein under. Your Lordship, I have read that. Mr. So-and-so, learned senior counsel appearing for the petitioner, by referring to Section 9 of the Act 2007, contended that for appointment of acting CM, recommendation of concerned CM clan is required. In other words, no acting CM shall be appointed without the recommendation of the CM clan. He also contended that the present writ petitioner, under his letter 25/7/2012, had informed the District Council as well as the other authorities regarding the constitution of CM clan, and a copy of the said letter 25/7 is available at Annexure 8 to the writ petition. As per the said constitution of the CM clan, it consists of 17 members. He further contended that there is no recommendation of the CM clans for appointment of respondent number 6 as the acting CM. So-and-so, learned senior counsel appearing for respondent number 1 to 5 contended that there was recommendation from the CM clan for appointing the respondent number 6 as acting CM. So-and-so, learned senior counsel further contended that the appointment of acting CM will continue until further orders of the Executive Committee. This court is accepting the proposal of so-and-so, learned senior counsel appearing for the respondent 1 to 5, to the extent that the appointment of acting CM is until further orders of the Executive Committee. Now the question to be considered is whether there was a recommendation of the CM clan for appointing the respondent number 6 as acting CM. So learned senior counsel appearing for the petitioner further contended that Section 7 of the Act 2007 clearly provides that no CM can be removed without giving an opportunity of being heard. He also contended that neither the show cause notice nor an opportunity of heard was available to the petitioner before passing the impugned order dated 8/8/2015, same month only, Your Lordship, for appointing respondent number 6 as acting CM in place of the present petitioner. So-and-so, learned senior counsel appearing for the petitioner by drawing attention to this quote, paragraph 15/16 of the writ petition, also contended that there was no notification for handing and taking over of the office who's aim of respondent number 6, and also that the petitioner is still continuing as his aim of Langren's aimship. Taking into consideration the submissions of learned counsel appearing for the parties, this court is of the considered view that the detailed affidavit and oppositions are required to be filed by respondents in the present writ petition. However, as per the materials available on record at this stage, and also considering the submissions of the learned counsel appearing for the parties, this court is of the prima facie view that in order to avoid chaos in the administration of Langren's aimship, and also not to make the present writ petition infructuous, an interim order is called for. As an interim measure, it is provided that the operation of impugned order dated 8/8/2014 shall remain suspended till the next returnable date, that is 4/9/2014. Now this Honourable Court, Your Lordship, in a similar situation, same petitioner, same aimship, had granted some interim measure, Your Lordship. The last paragraph is that liberty were granted to the respective parties to file any application for cancellation or modification of the interim order. Now, two grounds I've raised, Your Lordship, is that one, it was not placed before the Darbar. Secondly, that there's no recommendation. Now, on the first ground, Your Lordship, I would like to place this judgment which has been passed by this Honourable Court. This is a case where a complaint has also been filed. This is with regard to Jerungam's aimship. Here, Your Lordship, a complaint was filed before the Executive Committee. The Act also provides, and even the rules, that the same shall be placed before the Darbar Hima. Against the actions of the Executive Committee, the petitioner here, Nasar M. Jano, has approached this Honourable Court, Your Lordship. I'll just read the operative part.
Yes.
I'll take Your Lordship to the last 2 pages of this judgment, paragraph 12. This is a similar case where the complaint was not placed before the Darbar. This court already stated above that the construction of the statutory rule should be made in such a manner that every part of rule and regulation should be given effect, and the harmonious interpretation of the provision of the Act should be made so that no provision of the Act and rules would be redundant or surplus. In order to make Rule 28.4 of the said Rules 2006 effective, the Darbar Hima, which is going to consider the said complaint dated 7/6/2011 filed by the respondent 7-13, should not be presided by the Sardar or his relative, that is the Deputy Sardar, but only one of the member of the Darbar authorised by the District Council for this purpose. It is made clear that if the Darbar Hima requires the hearing of private respondent so-and-so while considering the complaint dated so-and-so, the private respondent so-and-so and also petitioner may be heard. The Darbar Hima shall consider and decide the complaint within 3 months from the date of receipt of the said copy of the judgment and order. Here also, Your Lordship, similar case where this Honourable Court has interpreted the law, whereby if any complaint is filed, it has to be placed before the Darbar Hima. And this judgment is still prevailing till date, Your Lordship. Now, Your Lordship, now whenever a new dispensation comes in District Council, the petitioner has been made to suffer. Why, Your Lordship? Like I've read the last order, High Court, that was at the time when a new dispensation came, I was suspended. And I approached this Honourable Court. This Honourable Court was kind enough to grant me some interim protection. Now in the year 2018, before closing of the courts and before the ensuing of the winter vacations, on 21/12/2018, I was again suspended. I came before this Honourable Court challenging the suspension. By then, an inquiry was already constituted against me, a one-man inquiry. We approached the one-man inquiry, filed a show cause, raised all these issues before the one-man inquiry of the District Council the one-man inquiry was constituted by the District Council. We went before him after considering the materials available on record. The one-man inquiry exonerated me. Then came to a finding that he should be reinstated back. On the basis of the finding of the one-man inquiry, then the Executive Committee of the District Council reinstated me back to my post as the CM of Langrin. Now against the reinstatement, Your Lordship, the particular person which I have read, Bolwister Semrong, the petition was filed by one Kensai Board Sim Yong and Mr. Granlywell Sim Yong. Now the writ petition is pending before Your Lordship. Now in that writ petition, Your Lordship, the District Council had challenged the maintainability of that writ petition. Your Lordship was pleased to dismiss the ground of maintainability and has further decided to proceed the matter on merit. Now against Your Lordship order, the District Council are on division bench now. They have filed an appeal against Your Lordship order. Now the entire stand now, Your Lordship, taken by the District Council is contrary and contradictory. On one hand, they're defending my reinstatement, and on the other hand, without looking into the records, what are the matters involving in the High Court, have on one hand suspended me. That is my third limb of argument, Your Lordship. Now, Your Lordship, the particular person which I've read, Mr. Bolwister Sim Yong. I'll take Your Lordship to paragraph 13 of my writ petition. Paragraph 13, page 9. Paragraph 13, page 9, Your Lordship.
Yes.
13A, I have already explained, Your Lordship, submitted regarding the one-man inquiry. How the District Councils are hell-bent defending me before this court. And now, on the contrary, when a new dispensation has come, they have suspended me. Now, secondly, Your Lordship, because the main allegation, because why they have freezed my account and allow me to spend only 25,000, that also with the permission of the District Council, DEC, is with regard to the land compensation which I have received. Now that issue, Your Lordship, is pending before Your Lordship. That is writ petition 153 of 2023, filed by Bolwister Sim Yong. I'll take Your Lordship to that. Annexure 8. Lecture 8, page 109.
Yes.
I'll read the prayer, Your Lordship, that is page 127, 128. Page 127.
Yes.
1. Your Lordship, direct the respondent collector for recalling recovery of the said compensation money, that is rupees so and so, from the respondent number 2 and 3 as per the 21 February within reasonable time frame. Direct the respondent Hima Langrin, including the respondent management board headed by chief, to refund the so and so amount to the respondent with reasonable time frame. Now this issue is pending before this honorable court with regard to the land compensation. Whether I should return or not, It's yet to be adjudicated before this court. Paragraph 13. Again, Your Lordship. Paragraph 13, page 10, page 9 and 10. Your Lordship.
Yes.
I'll go now to ground 3, 13C, that is at page 10.
Yes.
Page 10, Your Lordship. I'll just explain, Your Lordship, what is the backdrop as what led to all this dispute. Now, Your Lordship, there was a title suit number 3 in 1990, Your Lordship, that was instituted by the Darbar of Hima Langren versus Tylosis Imyong and others. Now, this suit was filed in 1990, and the suit was proceeding for 21 long years. Now, in 2011, a Darbar Hima was held. Then it was unanimously decided to end this long dispute for 22 long years, Your Lordship. It was decided to settle. Then a resolution was taken. Then a deed of compromise was executed. And then, Your Lordship, the compromise agreement was placed before the trial court. Now, Your Lordship, when the compromise was placed before the trial court, the case was disposed of. I'll take, Your Lordship, at serial number 1, page 10, Your Lordship.
Yes.
Status of the case disposed by order dated 18/4/2012 on compromise to the deed of settlement dated 14/10/2011. Serial number 2, the person which I have named, Your Lordship, Bolwister Imyong. He is the same person again from 2011. He filed for impleading. That impleading was dismissed on 5/3/2012. Now, against this dismissal order of 5/3/2012, Your Lordship, that is again at serial number 3, the same person, Bolwister Imyong, filed an appeal before the Judge District Council Court. Now, that appeal came to be dismissed again on 25/5/2012. Now, against the dismissal, his appeal was dismissed by the judge. Then he filed a civil revision for setting aside and quashing the order dated 25/5/2012. That revision again came to be dismissed by this Honorable Court, Your Lordship, on 26/7/2012. Now, in the order dated 26/7/2012, this Honorable Court was pleased to grant him liberty to ventilate his grievances on behalf of the villagers, in accordance with law. Now, using that window, Your Lordship, at serial number 5, again, Bolwister Imyong filed a suit for cancellation of the deed of declaration and the settlement, the compromise we had, Your Lordship. He filed title suit number 7/2012. And 632, Your Lord, kindly mark, 632 of them, they filed a suit, and that suit was pending till 2021. Now, 2021, we filed an application for rejection of plain. That suit came to be dismissed again on 28/2021. That suit also was dismissed. Now, in the first instance, there were 632, including the Bolwister. Now, he filed an appeal against that order, Your Lordship, alone, without those 632 people, for setting aside the order passed by the trial court. That appeal again came to be dismissed. Now, what has happened now? In collusion with some other Imyong clans, he fixed up another 5 people to file a miscase to challenge the settlement, Your Lordship. That serial number, it should be 7, Your Lordship, 7 and 8. 1 is for condonation of delay, and 2 is for setting aside recalling the judgment decree dated 18/8, Your Lordship. That also was dismissed by 7/6/2022, 7/6/2022. Now, Your Lordship, after that was dismissed, now again Bolwester came again by himself, by Miss Case 14 and 15.
What's the point of
No, I'm taking, Your Lordship, who is this Bolwester who is creating problems in Lawrence M-ship? Now he's failed in all these proceedings. He's challenged the land acquisition before this court. Your Lordship, now after failing in getting any kind of protection by any courts, all his case was dismissed. Now he has managed the Singh Samla to file a complaint against me before the Executive Committee. And all those grounds which are raised before the Executive Committee are pending before competent courts. Another allegation they made in the complaint is that I have gifted a land to the government official for setting up a school. Against that also, they have filed a title suit in Makurwat. That is also pending. Land acquisition is pending before this court. And my reinstatement also is pending before this court. To show the malified intent of Mr. Bolwester, Lordship. And he is the number one signatory in the complaint. Now the District Council, firstly, without complying to the statutory provisions, has suspended me on the basis of a complaint filed by some busybody. And whenever a new dispensation comes, I am the victim to these people to be suspended. Now this M-ship has been functioning peacefully for over a decade. Now there's always some interested people who want to disturb the peaceful tranquility of this M-ship, Your Lordship. Now, Your Lordship, when the issues are pending before this court, before the Makurwat court, before the District Council court, now the District Council, the Executive Committee, is making an attempt to usurp all the powers in them. Your Lordship, when the same are pending before competent courts, that too. Let the competent court decide. Why they come on the way and usurp the powers of the competent court? Let the Makurwat court decide, let the Judge District Council decide those issues, let this Honourable Court decide this land acquisition. Covered everything. And the impugn order which I have read, Your Lordship, its impugn notification is very vague without any reasons. Just saying I know I've been suspended and a new one has been recommended in my place. So firstly, Lordship, is that the statutory provision has not been complied. Section 7, Section 9, Rule 3.2, issues pending before this court, and complaint filed by busybody has simply entertained it without hearing me and suspended me. So that's, I'm praying, Your Lordship, that these two orders will be stayed till they file their affidavit in opposition and the matter be heard, Your Lordship.
Who's appearing for the...
And Your Lordship, I made a specific statement that I'm still continuing now as
District Council.
CM.
For District Council?
Yes, yes. In this particular case. Your Lordship, first of all, my friend has said that the impugnance order is vague. The notification that page 132, annexure 9. My Lord, it is vague because my friend has not challenged the actual suspension order which has been passed by the EC. Now this is a mere notification informing the same that he has been placed under suspension. But the suspension order per se, my Lord, is passed by the Executive Committee.
Was that...
that is a reason order.
No, was that communicated to him?
That's right, my Lord.
Unfortunately, my Lord, I received the notification on Saturday only. No order was supplied to me. That is why I'm before this court.
So the order has not been challenged, the order of the EC.
How can it be challenged if he is not privy
He should have got a copy, my Lord. That's why the records need to be called for. Because they filed it only today. In fact, the copy which we received today also is not official. We just got a copy from them. Anyway, my lord, just very short points. As I've said, the Act has been amended. Now, Section 7 of the Act, my friend has just read that, has been deleted by the amended Act of 2010. Your Lordship will come to page 307 of the Khasiels. There's part 2. Part 2, my lord, part 1 and part 2. My lord, is in 307. He fails to convene the annual Darbar Hima or Darbar Pulun, provided that the same shall not be removed from office or punished with the suspension unless he is given an opportunity of being heard. Provided further that the above proviso shall not apply in case where the order of removal or suspension is awarded on account of his being convicted of an offence involving moral turpitude. Your Lordship will see the last portion in the proviso to Section 7 is deleted and substituted by the Second Amended Act 2010. So that requirement of placing the complaint before the Darbar is no longer there.
This is
the proviso, which was originally there, which my friend had read out, that has been deleted.
Deleted by
Second Amendment Act of 2010. In the last part
but this is the Act of 2007.
Yes, but it was amended in 2010.
Only the complaint part was deleted. But
you will see the proviso.
Yes, I have noticed this.
That hearing part is still there, Lordship.
Proviso to Section 7.
Deleted. That proviso which my friend had read.
Regarding to complaint.
This proviso.
They have annexed the Act.
So this is the proviso which says that he should not be removed from office or punished with suspension unless he is given an opportunity of being heard.
Yes.
So this has been deleted.
No.
Only the first
portion,
part.
That portion where my
any
friend
complaint against the same should be brought to the knowledge of the Darbar Hima. Only that will be
The
deleted.
Lordship will come to page 28 of their writ petition. The Lordship will understand. 28 of their writ petition.
This book, I know.
My Lord will come to page 28.
Only the first part has been deleted.
So
28, my Lord. Well, you see page 28 after M, provided further that any complaint against the same should first be brought to the knowledge of the Darbar Hima, and the same shall not be removed from office or punished with suspension unless he is given an opportunity of being heard. So the first part has been done away with.
Only the complaint part. But shall not be removed from office or punished with suspension unless he is given an opportunity of being heard. It's still there.
yes.
That is there, my Lord. Supreme Court has interpreted that particular provision. I'll come to that. In the case of Himamilliam, in that case, my Lord, in fact, the same of Milliam was heard. Before the suspension order was passed, he was even heard. But then even then the Supreme Court said no. Even he has been heard, if the District Council intends to hold an inquiry,
Yes.
a further inquiry into the allegations, then there's nothing wrong with the suspension order. Lordship, I'll just place that decision. That's civil appeal number 4882 of 2002. The executive committee constituted under provisions of section 6.
Okay.
My Lord, we'll just come to page 2, para 3. Now, section 6 of the Main Act 1959 and section 7 of the Langren Sameship, these are identical.
Yes.
Section 6 of the Act contemplates, while removing or suspending aims referred to therein, an opportunity of being heard is to be given, but the said proviso is not applicable in cases of suspension pending inquiry. The order extracted earlier clearly indicates that the proceeding for detailed inquiry has been initiated and this aim has been placed under suspension pending inquiry. This aspect was completely lost sight of by the High Court. That's why, my Lord, I have to bring the records to show that he has been suspended pending inquiry. That is in the order of the EC. Because the notification they have impugned is merely an order that so-and-so has been appointed as acting CM. Now, the second point, they are referring to the rules. Perhaps my learned friend is also not aware that the rules were also amended in 2019, which has received the assent of the Executive Committee. Lord, I'm sorry, we will give you a copy of these rules. That particular provision in the rules which he has referred to, that also has been done away with. We have a copy, we will give a copy. That's why we need to file an affidavit to bring all this in record. Now look, the crux of the matter here relates to an amount of 15 crores. An amount of 15 crores. And my Lord will see what prompted the Executive Committee to. Your Lordship has seen that he has been, his powers have been taken away in regards to financial affairs. Your Lordship will just come to page 93 of the writ petition. What is the concern of the Executive Committee? When we had called for the records, for the explanation regarding the financial implications, Lordship will see receipt so and so and so. They have shown some 72 lakhs, but what is important is 94, my Lord.
Yes.
In page 94, my Lord will see. Note, the amount accrued from the land compensation is with the management board of Lao Langam Tila and Lao Pendeng Tangle, as the management board is a special body duly constituted for management of all affairs relating to these two properties. That is what the people of Langren Sameship are agreeing. Now, to show that this money does not belong to Langren Sameship, 15 crores has been kept in another account. It is not that the District Council, there is a change of dispensation and we have taken the step to suspend him. In fact, I think my learned friend has filed a writ petition before this court also, because this 15 crores has been released by the Deputy Commissioner Collector, despite the fact that there's a suit pending, not only against them, but also against the state. It is not that we have anything to against. Here we want that a proper inquiry should be conducted. And my Lord, I will furnish the records to show that the intention of the Executive Committee is to cause an inquiry by a competent independent person. And I have instructions also that the AIM clan, as per section 7, has already recommended the acting SAME to be appointed by the council. Records will speak for themselves. We may be allowed to file a reply. And then, Madam,
Your Lordship, with regard to the rules, which my learned senior said that in 2009, That has
So I
not been.
think what Mr. Linoa says is correct. I think we need to get all the relevant records.
But some protection, Your Lordship.
You'll get your interim protection. Come back on Monday.
Monday. Tuesday, my lord.
Heard letter counsel for the petitioner.
Your Lordship, just status quo order till Monday. Public. Not yet, Lordship.
No, status quo will only create more problems.
Your Lordship, prima facie, I've made out a case, Your Lordship, in my humble submission. Because, Your Lordship, 2009 with this saying has not been published, Your Lordship. The governor's assent has not been received.
Mr. Namburi, yes, all those, you see, your contention will be looked into, because now they have, you see, counter reply to whatever you have submitted. That is based on record. Now this court cannot, pass any order based on your submission if there is a response to that.
I understand, Your Lordship, but in the last case which I've read, Your Lordship, the last annexure, what does Honorable observe in the last paragraph?
It is in different context.
That, Your Lordship, have given them the liberty to vacate whatever, if there's new facts, new things have come, Your Lordship. But as a protective measure till now.
You say you're still in office?
Yes, I've not handed, because I've received.
Taken over.
Who are you?
Acting sir.
You are the acting.
Yes, they have taken over. That is why.
Where is your authority?
Saturday, Your Lordship, I received the notification.
Where's your authority?
Appointed.
Where's the appointment order?
Appointment.
That is the one.
Yes, that is the one.
Your
Status
Lordship,
quo, my lord, is going to
18, Your Lordship, we passed the order on Friday, Your Lordship, evening. I received on 19 morning. Where's the question for him to take over, because
My lord, my friend has withdrawn that huge amount during the pendency of the suit.
now again on that.
No, that is a different. We will not. That will be examined in the right.
My lord, from the district council, we will ensure that no more irregularities are there. That matter come up on Tuesday.
So we heard Mr. Pinogli, letter counsel of the petitioner. Also heard Mr. T.T. Rengo, learned senior counsel, appearing as counsel for the respondent, KHADC.
1, 2, 3 and 4.
Respondent 1, 2, 3 and 4, oblique KHADC. And Mr. H.L. Hangreso, senior counsel, appearing for respondent number. Number 5.
I think the notice will have to go to 6.
Oh, who's 6?
The complainant.
Yeah, important parties.
Then counsel, the petitioner is directed to take steps for issue of notice upon the respondent 6. Next, the petitioner have approached this court primarily being aggrieved by the impugn order dated. Where's your
18/7 and 18/8/2023.
page?
That is a page 131, Your Lordship.
131.
131 and
132 is the translated copy.
And Annexure 4, Your Lordship. Annexure 4 and Annexure 9.
Annexure 4 is page
90. Page 90.
Annexure 4 was passed way back on 18 July 2000.
It's a continuation, Your Lordship.
This just goes to show they don't deserve any.
Annexure 4 and Annexure 8.
At this stage.
And Annexure 9.
Yes, sir. Where is your annexure?
Annexure 4 is page 90. Annexure 9 is 131.
90, ma'am. This is dated 18th July 2023. That all the
And page 131 is the impugn notification.
Untuk apa pun dia? Ashok 18/7/2023, whereby he was directed by the respondent HCDC to furnish a detailed statement of account pertaining to the Langring steamship, and that his powers for withdrawal of funds of the steamship, of the said Langring steamship, was curtailed to 25,000 only, and also by atau pulih tu kelas suara tu kelas and also by a notification dated 18/8/2023 at annexure 9 of this petition, with translated copy at page 132 thereof, which has also indicated that the petitioner is suspended as far as his functions as aim of Langren steamship is concerned. The suspension order was to take effect immediately. The legal counsel for the petitioner has elaborately made his submission on practically the merits of the case, but has in the meantime prayed for an interim relief by this court in the form of suspension of the said impugn orders. Next, Mr. T.T. Dengro, Land Counsel for the Land Senior Counsel for the respondent KCDC, has, however, countered the said submission and contention made, and has also submitted before this court that relevant records are required to be produced to react or response to the contention or allegation made by the petitioner herein. Next, as far as the respondent number 5 is concerned, the Landed Senior Counsel, appearing on his behalf, has submitted that in view of the order dated, and in view of the notification dated 18/8/2023, he being temporarily appointed as the acting CM of Langren Chiefship, he has accordingly assumed office. This court, on consideration of the submission made, would not go into the details of the submission made at this point of time, and would agree with the learned counsel that the relevant records may be produced. In fact, it would be appropriate for the respondent to file an affidavit in opposition so as to dispose of this matter at the earliest. As to the prayer of the petitioner for interim relief, in the light of what has been submitted by the respondent 5, the respondent 5, on assumption of office, would have acquired a right for which he is entitled to be heard thereof. What protection can I give you? He has already assumed office.
No, Lordship. I made a specific statement that I'm still continuing office, Lordship.
How is he now that is a disputed question.
Kindly have a look at the last order, Lordship, the last annexure. This honourable court, on a statement made before court, has suspended.
Those are different facts.
He has made contradiction.
Facts is the same. Recommendation is the same, Your Lordship.
It's not the same.
Identical, Your Lordship.
Here is a case where I'm stating that he has been recommended, the acting CM. It's on record.
If he has assumed office, he has to show something that he has assumed. You just can't make a statement and say, I'll file affidavit and delay the matter. That's why I'm saying till the matter is heard.
My Lord, as with this council, we have been facing a lot of difficulties with status quo. Because both sides then will come and say, I'm in possession, I'm in possession.
Kindly stay the order, Your Lordship. Everything will be put to an end.
Your Lordship will stay the order at this stage. They say they have taken over, then what happened?
My Lordship will not go into this confusion.
Suspension by law is to enable the district council to conduct a free and partial inquiry. If the gentleman is still sitting in the chair, how will conduct a fresh inquiry? Because of that, my Lord, appointment has been given.
If they have taken over, Your Lordship, they have to show by materials before this court that they have taken over.
So, next, pomno iti last lang mo. To learning at correct. In the light of the statement made by the learned counsel for the petitioner at the bar, that he is still in office, and the contrary statement made by the learned counsel for the respondent 5, this court is of the considered opinion that as on today, status quo shall be maintained till further orders. Matter will be heard, matter will be taken up on the next date fix. List the same on. When did you say we fix it?
Because they have notice has to go to 6 also.
Oh yes, you have.
I'll take steps on 6.
So 28 then.
Yes, ma'am.
Can you do it by
30th?
We'll try to serve them dusty and by registered post also.
Let it come 30th.
30th.
You can prepare your affidavit also by then. List the matter on 30th.
Much.
Obliged.